Hello, 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 hello. So, fucking pro se litigant, stout, and fucking stout on my ass up in here. Someone told me that I needed to watch this. I watched about 2 minutes of it and then commented, because my name was running across the inmate's lips, the convicted prison lawyer running across his lips. And whatever. The last time I had any real interaction with this fuckwad was he demanded we debate. I don't remember the exact topic. I think the exact topic was if I think is the exact topic we were supposed to debate, if I remember correctly, was if city halls are limited public forums. And my obvious position would be that it is not decided yet whether or not each is. So each one that you look at, you're going to have to look at the individual facts. The court's going to have to make an analysis based on the facts of that particular city hall. Like at that city hall, might have areas that are free speech zones. They might be designated public forums within the city hall. So just because it's one building doesn't mean that it is a single entity. For example, a military base is a non-public forum. I can't get drunk, bro. I would love to get drunk, WTT. A military base is a non-public forum. However, apparently I'm an alcoholic or whatever. I don't really care. But a military base is a non-public forum. But a military base can have free speech zones in it. Like the Vandenberg, what is that? U.S. Supreme Court, U.S. Supreme Court, Vandenberg. Appel. In Appel, we're going to share this tab instead. Hold on a second. Why is it sharing this tab instead? Oh, wait, hold on a second. I'm on the wrong thing. I only have one monitor. Okay. In Appel, the base is obviously non-public forum, but in Appel, they had a specific spot that was a traditional public forum. They set aside, it's a designated public forum. They set aside a free speech zone. And if he had, well, it's about him being trespassed from the base entirely, but so just because it is a thing doesn't mean it can't have other things in it. You know what I'm saying? And it doesn't mean that at all times, because like a city council meeting where they invite public participation, it's going to be different. It's still a limited public forum, but and as long as you're on topic, they have less they can do about you as long as they treat everybody fairly. So different forums, a single building might have different forums in it at different times. Or for example, they might open up a school gymnasium for movie night. Now, normally a school is a non-public forum for everybody except for the students, for which it's a limited public forum. But if they open up the gymnasium for movie night, that might change what it is for that night. You know what I'm saying? So it's a complicated fact pattern that a court would have to look into. That's what we were going to debate. And right before the debate, Kate, if you could trust Kate would vouch for me that Stout was like, oh, hey, you know what? I don't want to talk about that. I want to talk about Sheets versus City of Punta Gorda. And so I'm like, okay, like this is like literally right before we're about to go live. I'm like, okay, like whatever, dude. And then he went on to say like, this is Sheets versus City of Punta Gorda. Like that was a fucking debate. I'm like, yeah, that's Sheets versus City of Punta Gorda. And then like, do you want to make some extrapolations from that? Like what would happen if what would happen if busloads of Japanese tourists came every year because it was a historic city hall, and they came in and they took pictures, and no one stopped them from taking pictures. But then a auditor came in and wanted to take pictures. What would happen then? How would the court analyze it then? Oh, I can't extrapolate out from that. I can extrapolate out that every single city hall in the United States is a limited public forum because the parties agreed that this specific city hall was a limited public forum. From that, he can extrapolate every city hall is a limited public forum, but he won't talk about like the facts. So anyway, that was how scholarly and honest and forthright he was. So we're going to put him on 2x speed, and I might get a little bit animated. I mean, I'm literally being called out. I have a bar card. I'm held to a certain standard, and I'm being called out by a fucking prison attorney, by a guy who got his experience by litigating, which it's not like building a car. It's not like that. Practice does not necessarily make perfect. That's why they have things like vexatious litigant laws, because practice does not necessarily make perfect. You don't necessarily learn from your mistakes. Is this the same guy with less or equal to a high school diploma talking about case law? I recall he was smashed at a debate. I don't know. I mean, I don't really care if people think I won or lost that debate because there was no fucking topic. He wouldn't actually debate me on anything in it. That's why I was just laughing at him the entire time. He was just like, yeah, this is Sheets versus City of Punta Gorda. Yeah, okay, cool. You want to talk about it? You want to discuss it? Oh, I can't extrapolate out from it. To the courts determine what the speech is in their analysis. I mean, they may, if there's a question about what is, like if something is or isn't speech, the courts may have to determine that. It's that is something that could theoretically be up for debate. Yes. Or generally speaking, usually the parties agree that this was speech, was some sort of expressive activity. It's normally agreed on, but what do I know? I'm just an attorney. All right, so let's get this ball rolling here.
Can everyone see me and hear me? So Rogue Nation brought something up. It's actually neither here nor there. I already know about all of this. I know everything about her case, folks. All right. He says
he knows everything about her case.
Just found this information. I already knew this information. There is court. I mean, there's a website, a Cook County government website, that basically keeps track of the county's finances, and there is evidence. Right. There's a receipt that the law firm that represented her. Actually, I don't even know if it's that specific law firm, but the law firm that represented her received $15,000 in the Berquist case. All right. Now, that's not the claim, though. That's not the claim that we're discussing. The claim is that Berquist herself received $15,000. That's the claim, is that she received it. And folks, I'll tell you the difference between the firm receiving it and the client receiving it. Okay. And there is a big, big, big difference. When the client received the $15,000, they received $15,000. But when the firm receives it, right, some or most of that money may not even go to the client. You want to know why? Because the client may owe attorney's fees in the case, or has agreed to pay a percentage of has paid attorney's fees and agreed to pay a percentage of the settlement if the case does settle. So,
yeah. And for those of you who aren't aware, we'll make it bigger. This is the notice of voluntary or agreed motion for voluntary dismissal. Solomon Rader, you may remember him. He was the attorney who initially started the representation of the Leon Valley plaintiffs. He has a lot of experience. He's practiced a lot of law for a lot of law firms. He's done a lot of his own law. He, at any given time, the guy will probably have 10 civil rights cases going. He's got a shit ton of experience, and he does these things. There's two ways he does it, and I'm only guessing here because I've never seen his agreements with the clients. But he could get, if they're entitled to, and he recovers attorney fees under 42 USC 1985, he would get those, and then any agreed on contingency fee arrangements. None of the plaintiffs have paid him out of pocket, as far as I'm aware. Hey, Mr. Sun, how you doing? Hold on a second. I gotta stand up. All right, I'm back. That sun was just, it found a break in the clouds right in my eyes. So he gets paid contingency fee. So he doesn't get paid unless they get a settlement. So what Dumb and Dumber here is saying is true. The check does go to the law firm, and then the law firm will usually goes. It's made out to both the party and the attorney. This is how I receive them normally. So I'm going to assume that it's normal, because every case I've settled on contingency, there's come in a check for me and for the client, and we both have to sign. I deposit in my trust. When the check clears, I write them a check for their portion, and everybody's happy, scrappy, hero pup. So that's normally the way it works. So what we get, you could quibble about the fucking settlement amount, but the fact is that they paid her, so she won, right? If what she was looking for was monetary relief, in her prayer she asked for money damages. If she received money damages, she wins. I think she sued. I don't think she did a suit against the city. I don't know that she did a Manel claim. I don't remember it very well, but she definitely sued like the police officer who arrested her. So he didn't necessarily lose because he probably, the insurance company probably paid less to Pink Camera Magic than they would have paid the attorney to defend them at court, if that makes sense.
And here's what happens. A lot of times, and any attorney in here knows this, right? What'll happen is a lawyer will take on a case, and then what they'll do is they'll attach an attorney's lien. It's called, they put a lien on any settlement receipt, right? They put a lien on it, and it's called an attorney's lien. And what that does,
well, you don't put the attorney's lien on it unless so like if say for example I had a client who I was representing on contingency. My contingency contract has language in there about my hourly rate if they fire me, and they owe me that money if they fire me. So if they fire me and then they get another attorney to represent them in the lawsuit, I file a notice of lien, and I inform the other attorney of my lien, and then at the end of the day, it's between me and that other attorney to work out how much we get paid, because the client isn't going to pay for both attorneys, if that makes sense. So the client's just out the amount of money, like for as if they had one attorney, and then the attorneys are in there squabbling over who gets the bigger share, who did more work, etc. So that's the way attorneys liens work. While you're in the case, while you're representing the client, I've never filed an attorney's lien in it. I've never heard of another attorney filing it while they're still representing the client, because you don't need to. But okay. Now I'm sure that Mark has represented a bunch of clients, and he's filed attorney liens, so he knows all about it.
Does is it makes sure that the law firm gets the money and they get paid first before the client. It makes sure that the client can't just get the check and run off with the money and never pay the attorney.
No, again, that you don't have to do that, because the defendant will write the check out to the law firm and the client, and both parties have to sign it. Generally speaking, you might theoretically be able to convince the defendant's attorney or the defendant to have the check cut to just the law firm if there's like a bunch of clients or something like that. But generally speaking, like since Amanda Berquist was the only plaintiff in this case, the check, if she pops in, she could probably tell us. I see Chi-Town Sue's here. Hi, Sue. But if she pops in, she could tell us the check was probably made out. She could tell me I'm wrong, to Radner or Radner's law firm, and then to her. It was made out to both, so both would have to sign it. It gets deposited in Radner's trust account, and then he writes her a check for her portion.
Okay, so it doesn't mean anything that the firm received $15,000. I already know that.
It does mean something that the firm received $50,000, because that means that the defendant paid. Like, if you're just quibbling about amounts, who really fucking cares, right? If they paid $1 or if they paid $100,000, either way they paid. Like that, I don't know. Like, they still paid. There was still a settlement. There was still a monetary settlement.
The claim is that Amanda Berquist received $15,000, and there's a difference between her receiving it and her lawyer explaining her case to get.
I never claimed that she got 15 grand. I just said she got a settlement, and she did get a settlement. I could tell she got a settlement because if you remember this right here, Federal Rule of Appellate Procedure 33 deals with mediated settlements. So that's how you know. That's how you know.
He can't out of it. There's a big difference. And again, Berquist has not provided any documentation. And until she provides case documentation, or it doesn't even have to be case documentation anymore, show us a letter from your lawyer saying, here's your settlement check, or show us a check in your name from your law firm, from Johnson Law.
There is probably a non-disclosure. Normally these things get handled in a way where there is a non-disclosure agreement between the parties, and the defendant will, generally speaking, demand that, because the city doesn't want to have a bunch of these fucking lawsuits with people just hoping for settlements, or they don't want this to get used as like a starting point for the next lawsuit that's similar. Oh, well, you paid Amanda 15 grand. I want to get 15 grand, right? So Amanda probably cannot produce the check. She probably cannot produce any of the settlement agreements. But you have independently ascertained, according to you, through city records, that she received a settlement. Ergo, she got a settlement. Ergo, quaderat demonstratum. I don't know if it would be ethical for a contingency attorney to retain the entire amount. I would guess that it would not be ethical. I wouldn't expect a prison attorney to know anything about it, or to have any ethics in the first place, because this bitch is up here giving legal advice, and he's a goddamn felon, or maybe he just has misdemeanors. I don't know entirely. Well, no, he went to prison, so he's got to be a felon, right? And this motherfucker's out here giving advice. Jesus fucking Christ. He's holding himself out to be an expert in his fucking mom's garage with his little fucking diplomas behind him. Fucking
law firm with show us a $15,000 check. Show us a letter stating, you don't have to show us the check. Show us a letter from the law firm stating there is a check for $15,000 enclosed. Show us that, and I'll concede the point. You think I want to sit here and play these stupid games? Come out with the documentation and just prove what you're claiming. Now, Berquist isn't making these claims, but other people are. Okay, the frog is making.
She probably can't make these claims because, again, there's most likely a non-disclosure agreement. A non-disclosure agreement means she can't talk about it.
Making these claims, and so is Merb. Okay, and they're claiming that Amanda Berquist received.
Wait, hold on a second. So is Merb? The
frog is making these claims, and so is Merb. Okay.
Where did I make a claim as to the amount? This is the first time I've heard 15 grand. All I've ever said was that she received a settlement. So this piece of shit's lying on me already. Fucking find the place where I said before this stream, find the place where I said that Amanda Berquist received 15 grand or Pink Camera Magic received 15 grand. You can't, because I fucking didn't.
And they're claiming that Amanda Berquist received $15,000.
This is his fucking MO. Like, I was there on Frog's stream. I was there, and he was saying that she received a settlement. I never heard shit. I did not hear Frog say. And if Frog, he's probably asleep by now. But if Frog wants to jump up here and tell me otherwise, I've never heard Frog made a $15,000 claim. So what he's doing is he's changing the argument. It's a straw man. He's changing the argument from what the argument was, i.e., that she received a settlement, to what the settlement was. Oh, wait, you said it was a 15 grand settlement, so you're wrong. No. We just said it was a settlement. So we're right. Fucking disingenuous piece of shit.
And the records reflect that she never received anything. Records reflect at the very least, at the very most, Johnson Law PLC received the $15,000 check. And for all we...
Well, again, but that is so highly unlikely, because there is going to be an upper limit on the contingency fee you can pull. There's going to be an upper limit. Frogs don't sleep. Well, I think the frog does. the Frog UK Transparency, I think is his full title. Fucked. So I believe he sleeps.
We know she owed them that, or possibly even more than that. For all we know, the law firm could have taken 50. We don't know even if there was a percentage split or what it was if there was. She won't until she herself provides proof. None of this means.
Why does she have to, like, she got a settlement? Like, why does it matter? I don't, maybe I just haven't got there yet.
Anything. So we're going to go through these claims. All right. So again, they're false claims. Until it's proven otherwise, these are false claims by the Frog and by Mer. Hello, everybody. What's up? All right, let me take that off the screen. And I'm not even going to go to that website because I already know what that says, but that's not the claim, though. So while it's good for background information and it provides a little bit more context, it's a moot point. It's a moot point whether or not her law firm received the money. Okay, that's not the claim here.
It doesn't even like make sense. Yeah, I mean, like what basis would frauded or troll have to determine whether or not Mark Stout is knowledgeable about the law? He doesn't. He has no basis to make that. But it's just hilarious to me. Like, they can't find a fucking attorney to tell me I'm wrong. I mean, we've got attorneys on here. You've got Paul Carroll. You got Juan Galt. Juan Galt's fucking here right now. I mean, he could pop up here and tell me I'm full of shit. He could pop up here and tell me that Mark Stout is the best thing since sliced bread. With all these fucking attorneys floating around here, you would think the frauditor fuckwit side of this equation you think that they would be able to find someone with an actual law degree. They pull fucking Stout, they pull AZ Jeep Girl, who's not an attorney. Like, why is it that attorneys are saying one thing and a fucking prison litigator, Stout and Stout pro se litigants, is saying another, and they're fucking listening? They're like, I don't really fucking care. Just tell me what I want to hear. Tell me what I want to hear. I'll listen to fucking anybody who tells me what I want to hear. You could be some crack whore on a street corner. If I pay you $10 and you tell me that the frauditors are all bad and wrong and they always lose, then hallelujah, I'll give you a YouTube channel and I'll pay you money every month to tell me that the frauditors are always wrong and they always lose. This dipshit is trying to slice the fucking cheese so thin that the law firm, that Amanda's law firm, got a $15,000 check and Amanda got nothing. And Amanda agreed to this just for fucking shits and grins. Amanda's like, you know what? That sounds like a fucking good settlement. You know, that sounds like a really fucking good settlement. I'm going to go ahead and take that settlement because Amanda agreed to this settlement. She agreed to it. She has a contingency attorney. She's not paying him a fucking dime. All right. So number one, there's two things that you could tell. And I've always said this, and I'll say this again. If you go to an attorney and he takes your case on a contingency basis, you probably got a reasonable case. No guarantees you're going to win, but he thinks that he is going to be able to prove that there's liability and there's damages, or he's going to be able to get you a settlement. One of the three. He thinks that he's going to get paid, right? He's putting his fucking money where your mouth is. He thinks it's a winner. If he says, no, I won't take it, or if he says, I'll take it, but only if you pay me on an hourly basis, then you know you've got a shit case. There's either a problem with damages or there's a problem with liability. Or maybe he just knows that the opposing side is not going to settle, and so it's going to be way too expensive to litigate it all the way to the end. So you have an attorney, Solomon Radner, with a shit ton of experience, he was representing clients in Illinois. He's representing clients in Texas. He's doing a court of appeals case in Illinois. I mean, the guy has experience. The guy has fucking experience. And he thinks his case has value. He thinks it has legs. He's willing to take it, right? So he's like, yeah, let's go. Amanda, she's like, I got fucking nothing in this. Maybe a couple filing fees, maybe about $800, give or take, right? No big fucking deal. Let's go. Let's do this, right? And then they're like, hey, let's settle. I'll pay your attorney $15,000 and I'll pay you nothing. Well, first of all, they can't do that. They could just be like, we're going to pay 15 grand, right? But you know what? Hold on a second. Does it say? Oh, well, hold on a second. So we know that the attorney's fees. Oh shit! Hold on a second. You can't see this. No, you can't. All right, perfect. I keep getting confused. I only have one screen right now. So if you look at that, each party bear their own costs. So neither side is paying attorney's fees. So of that 15 grand, it can only be split by the contingency fee agreement. Only because no one's paying. These are not attorney's fees. And if Mark Stout wasn't a fucking idiot, he'd be able to tell you that, because he'd be able to look at the fucking motion for voluntary dismissal that Amanda fucking agreed to, and her attorney agreed to, and the city agreed to, or the was it the city? Let's fucking look. I don't know who all, but the defendants, Donald Malazzo et al. So everybody fucking agreed to this appeal, and that's a good one. That's a good one. But like, so everybody agreed to this. There are no attorney's fees being paid, so it has to be contingency. So she had to have received some of that money, and I would bet you she would not have agreed to a contingency much higher than 50%. If 50%. I know. So fucking Stout. I've got 2 fucking attorneys in my live stream, neither of which are calling me out for being fucking wrong. And how many attorneys do you have backing you up? You got fucking nothing, dude. Goddamn prison attorneys. Thank you for popping in, Paul.
Warriors Rage, what's up? C. Allen, Potluck, Greg, Trick, bro, made $15,000. Well, I was going to talk about it, but I wasn't going to visit the website. And I'll tell you why. I have no problem with lawyers exploiting fraudulent cases and getting paid. I get it. I myself have done it before.
Well, two things there. I have no problem with lawyers exploiting fraudulent cases to get paid. Well, I mean, like, exploit, like, that's like, I have no problem with lawyers exploiting car accident victims to get paid. I mean, are we exploiting car accident victims to take their case to get them a settlement? Are we exploiting people in medical malpractice who've had doctors make errors in their treatment? Are we exploiting the patients who we represent? Like, and number 2 is, this motherfucker has represented our Mark Stout of Stout Stout and Stout Pro Se Litigants. Are you telling me that you have represented someone? Because that'd be a mighty fucking dumb claim for you to make, sir. But you're the kind of dumb who'd make it.
Or when I frauded it. Okay. I have no problem with lawyers getting paid. That's what they do. I'm not going to knock their hustle. I'm not going to go, put that out there and try to expose them. I want the law firms to go ahead, get your money. Get your money off these fools. Okay. As long as it's you getting it.
Solomon Radner did not get his money off of Amanda Berquist. He took what she had, which was potential, and he turned it into reality. And in exchange for doing the work to take her potential and turning it into reality, he got probably about 50% of what she got. So she probably got about $7,500, and he probably got about $7,500. It might be more, it might be less, because it did go to an appeal. It might be like a 2/3, 1/3 split. He might have gotten like 10,000. She might have got 5, because that's the way it works. The attorney does more work. He wants to get paid more, right? But at the end of the day, he took potential and he turned it into reality. She had the potential to get money, and he turned it into like $5,000 to $10,000 in her pocket, somewhere in that range, I would assume.
As long as it's the lawyer getting it and not the frauder getting it for themselves. Okay, because I'll expose the frauders. Okay, and I will do it ruthlessly. Okay, but I'm not going to go after lawyers. Me and lawyers get along very well. Okay,
me and lawyers get along very well. Well, here's a fucking lawyer who you're not getting along well with, because you're talking some stupid shit.
A lot of developed relationships with a lot of attorneys. Okay, I would never try to expose.
I have developed relationships with a lot of attorneys. What? As the public defender defended you? Is that a relationship? Or as the district attorney prosecuted you? Is that a relationship? Or is it that when the attorney that the city or the state hired to defend themselves against your frivolous fucking suits? Which fucking case have you won? Stout, and Stout, pro se litigant. Why don't you show us your letter? Why don't you show us your letter from a law firm or from a defendant with your check? Why don't you show us that? Or did you sign a non-disclosure agreement?
Because that's what it would be doing. That's what I would be doing if I did that. You know, I'm not going to put the firm up here and, you know, let them get paid. All right. That's my thoughts on that. So those are my thoughts. All right. So Hubcat.
Did he really? Because that would be sad. I mean, I'm not saying that the armed fisherman had a case. I haven't actually looked into it. I did catch some of Frog covering, what was it, Fraud at Wrangler? Going over the appeal, and it looks like the armed fisherman didn't respond to something, so that they had to assume all the facts in all the uncontested facts in the favor of the defendant. So, you know, that would be sad. Like, at least if an attorney was representing the armed fisherman and a ball was dropped like that, then the armed fisherman may have some recourse against the attorney. And, you know, but if this fucking prison attorney was representing the armed fisherman, then, well, obviously he can't sue this guy because this guy isn't an attorney.
What's up, Hubcat? Good citizen. Another lost soul. How was everybody? Shaban? Strange Lex?
All the fucking greetings. God, I hate those.
So let's see. Is there any proof? Can we find any proof anywhere that Amanda Berquist received $15,000 in settlement money? Can we find that proof anywhere? We're going to go through the case, and we cannot. So until you can, that's a false claim. All right. Now let's go to my post. Now, can everybody see my post relatively well?
And again, like, she received some money. She wouldn't have agreed to the settlement if she didn't receive some money. Yeah, it's exactly like that. It's exactly like that. Huh. Well, if that is true, I mean, that's fucking not good. It's fucking not good. I'm not saying that there is, but there might be an action that the armed fisherman might be able to bring against Mark Stout if that is true. Might be. I mean, I'd have to look it up, but you get in big problems representing people if you don't have a license to practice law.
No. You can't see my post? Yeah, yep, you can. Okay. Let me see if some more people answer. Okay, yep. I have to go back and forth. If I want to see what's in the chat, okay, good, okay. I have to go back to another screen, so. Okay, I posted this to my community page like a day or two ago or something, all right?
Oh, look, he's got actually 3 diploma thingies behind him. And then the one that's backwards that he was all super proud of. So he has it up there, but he can't show anybody. Like, what a fucking weirdo.
September 28th, 2022. And this community page post was in response to a video I saw on the Frog's channel. And in the video, Frog was claiming, and Murr was claiming that Berquist received $15,000.
Why has this cat got my fucking name in his mouth? Like, I never claimed that. Like, show me where I claimed that.
Okay. Or any amount of money. All right, any amount of money. They said they claimed that she received a monetary settlement in whatever amount that.
Yeah, it's a $15,000 settlement divided in some undisclosed way between her and her attorney. Yeah. The defendants paid out. That's a win, right? The defendants paid out.
It really doesn't even matter at this point. If she can prove that she got any money, I would be probably satisfied with that. There's no evidence that she received anything, people. So on September 28, 2022, a federal.
I guess if you can't draw a straight line between the motion to dismiss stating that each side is to bear their own costs, i.e. attorney's fees, filing fees, all that fun shit. I mean, I guess technically they didn't spell out attorney's fees, so I guess you could fucking the settlement agreement though. I mean, there's no way they're going to settle for attorney's fees plus the contingent amount, and there's no way that Pink Camera Magic is going to agree to a settlement if she's not getting something out of it. Because again, proceeding with the appeal costs Amanda nothing. She's not paying anything unless she recovers something. So like, why would like I don't understand why she has to prove this. Like, this is like John, unless you prove that you don't piss in your house and hide the smell of piss with fish tanks, unless you prove that you don't do that, then we have to assume that you did it, right? It's so fucking weird. It's just so fucking weird that that he's bending over backwards. She got a settlement for 15 grand with a contingency fee lawyer that she agreed to. Like it's everything would suggest like there would have to be some weird fucking circumstance that would make me, who's actually had contingency fee agreements with clients and who has represented defendants who have had to settle. I've seen both sides. I've seen the plaintiff side. I've seen the defendant side. I know settlements. I'm fucking scheduled for a settlement, a private mediation at the end of the month. I mean, if they agree, because the attorney can't agree to a settlement, that is entirely up to the client. It's entirely in the client's hands. The attorney might think it's the best deal ever, and if the client says no, that's it. It's no. The attorney might think it's the worst deal ever. He has a duty to report the settlement offer to the client. Like they said they'll settle it for $1. Well, fine, we'll take it. Shit, we could get like $100,000. Nope, I want it settled for $1. Boom, done. There's nothing the attorney can do. So Amanda agreed to the settlement. The attorney had no say in whether or not she agreed to it. No say. I mean, he could make a recommendation, but that's it. So Amanda, who's paying nothing for her legal services, thought that it was a good idea to accept this offer. And you're going to say that unless she proves she received money out of it, that like, well, I know. I was sneaking off to soak up whiskey or something like that. What about if the lawyer was on contingency and was owed funds? What about it? And I really mean like, what about it? Like, maybe I don't understand your question. If the lawyer is on contingency fee, a lot of times lawyers on contingency fee will advance the costs of litigation, like the filing fee and the and then the appeals filing fee, cost of service. In regards to settling, no, he has no say. Absolutely no say. It would be a violation of the rules of professional conduct. He cannot tell he can say, I recommend you take it. I suggest you take it. You really should take it. But all he could do is like try to cajole the client into taking it. He can't. It's up to the client. If the client says no, then no. If the client says yes, then yes. There's no. That's it. That's the end of the discussion. So he awards the client the $1, and then. Well, so if the client owes him $400, excuse me, for the filing fee, and the client agrees to a $1 settlement, well, then the attorney would probably keep the $1 as, whatever, 50 cents was his, 50 cents would go towards the $400 the client owes, and then he'd send a bill to the client for $399.50. Isn't he owed for his work? No, but so there are some things that are not contingency agreements. He might be. There are hybrid kinds of agreements where he might, like there's an attorney that I work with who likes to do it on an hourly basis against a third of the retainer. So instead of getting like his staggered fee that can end up being 50%. He'll do it for $100 an hour against 1/3 of the recovery. And so that means, like, if let's say he bills $10,000, so there's at $100 an hour, that would be what, 100 hours. If he bills 100 hours and the client's paid him $10,000 and he gets $100,000 recovery, instead of getting $33,333.33, he'd get that money minus the $10,000 he's already paid. So he'd get $23,000, etc. What if they're continuing? So yeah. So a lot of time in contingency agreements, it'll be like 1/3 of the recovery after costs. So if it's $100,000, if the client has advanced the fees, then the client gets paid the fees off the top, and then the rest is split. If the attorneys paid the fees, the attorney will take the fees off the top to pay himself from the fees, and then the remainder is split. So that's the way that would be handled. Contingency has its risk, but greater reward generally. Yes, generally. Greater risk, greater reward. Absolutely. A lot of attorneys will work off a percentage, 30 to 45%. With the attorney, you just get around 30 to 45 cents. Then, that's exactly the way it would work. And then, are there limits on how much of a settlement that the attorney can take? I think that would depend on the local state bar. Would probably have some sort of rules on that. If the recovery is unreasonable, then the client does have some means, like a mandatory fee arbitration, things like that they can use to try to get around that. But I don't know if it's like universal across all the states but my gut instinct is that most states are going to have some sort of a state bar ruling on like what the maximum percentage is, and that maximum percentage probably goes up if, like, it's probably a maximum of, like, maybe let's say 45 or 50% if you go to trial, and it might be like 66% if you go after trial, if you go to appeal, etc. But it's yeah. And yeah, it is a raw deal. It's high risk, high reward, and that's the fun of it. You can make a lot of money, and you could also lose a lot of money.
District Court dismissed Amanda Berquist's, aka Pink Scammer Magic's lawsuit. Berquist's lawsuit alleged that a judicial order prohibiting filming on courthouse property violated her First Amendment rights, and that her detention for filming on courthouse property violated her Fourth Amendment rights. The court ruled that the defendants had reasonable suspicion to detain and probable cause to arrest Berquist. The court ruled a reasonable officer had probable cause to believe that plaintiff violated the general administrative order prohibiting filming inside the courthouse, as well as the Illinois statute prohibiting disorderly conduct. The court dismissed Berquist's lawsuit and ordered Berquist to pay the defendants over $5,000 in attorney's fees.
There's a different dynamic in cases like that. God, why is the name class action? I don't know why that wasn't coming to me. I've never done a class action, but those things are ridiculous because the attorney, like, really the only person who wins in a class action is the attorney, is a law firm. Like, everybody else gets like $2 or some shit like that, and then the attorney gets millions or hundreds of millions. It's a fucking great thing to get if you can get it. I have no sense of taste or smell, and I am like, literally no, like, I can't smell Vicks Vapor Rub. I can't taste coffee. It's crazy, and I'm congested and coughing. But other than that, it's pretty great. I hope you're doing well, Nasty.
Berquist filed an appeal. During the appeal, the parties engaged in mediation. During the mediation, the parties came to an agreement. To the best of my knowledge, the defendants agreed to waive the attorney's fees Berquist owed them if Berquist agreed to voluntarily dismiss her appeal. The defendants' attorney's fees in the case, including the appeal, would have been between $10,000 and $20,000.
To the best of my knowledge, well, like, to the best of my knowledge, defendants agreed to waive the attorney's fees that Berquist owed them if Berquist agreed to voluntarily dismiss her appeal. That probably was factored into the settlement agreement. Yes, that probably was part of it. But like, why is he taking that to the best of my knowledge? Why is that gospel? But with the knowledge that she agreed to the appeal, with the knowledge that the city wrote a check to her attorney for 15 grand, with the knowledge of those two things, like why is it that we can accept to the best of his knowledge that the attorney's fees that she owed were waived as part of the settlement agreement, but not that she received any fucking money? Like, I just, can the percentage of attorney gets depend on how difficult it will be to win or get a settlement? Maybe. I mean, that's between the attorney and the client to negotiate. The client you could negotiate your contract with the attorney. Normally, like my contingency agreement is a tiered contingency agreement. So if all I have to do is write a demand letter, I want 25%. That's it. 25%, easy peasy lemon squeezy. All I do is write a demand letter. They see my name on it and they pay you. Never happened yet, right? The next step is that if I have to file a lawsuit, that's generally speaking, that's going to cost me time and effort. I'm up to 33 1/3%. If I have to go past that, if I have to go to mediation or arbitration, well, not arbitration, mediation, then I'm going to want 40%. And if I go to trial, I want 45%, trial or arbitration, because there's really no fucking difference between the two of them as far as I'm concerned. So that's my contingency agreement. Other attorneys I work with have scales that go up past that. Like one attorney I work with, he tops out at 50%. I haven't seen the contingency agreement for the other law firm I work with. Sorry, I didn't get to the mutant time. But I'm sure that they could possibly this is going to be a really difficult case, so I'm going to want a higher percentage, maybe. I believe that Mississippi has not rules on what percentage the attorney can take, mostly because no one there understands or can calculate a percentage. Ouch. So if I suffer $100,000 damage, do I sue for $100,000 and pay the attorney $40K, or do I sue for approximately $160 and pay $60? Well, first of all, how do you know you suffered $100,000 in damages? There are essentially three kinds of damage, and they can have different names depending on where you're from. There's specific damages. Those are things that you can actually have a receipt for. Let's say you get in a car accident. You go to the hospital. There's a medical bill associated with your visit to the hospital for your prescriptions, for your physical therapy, for your chiropractor, etc. Those are specific damages. There's not a lot of debate on those. I mean, you could debate on, you had a pre-existing back injury, so is this really part? Maybe we'll assign 70% to the current injury and 30% to the prior injury, whatever. But just generally speaking, you got a fucking receipt for it. It's specific damages, right? General damages are the things that you can't produce a receipt for. General damages are things like loss of consortium, pain, suffering, humiliation. Just like I used to be able to carry my groceries in, but now I have to get my grandson to carry my groceries in for me, right? It's all those intangible things. And generally speaking, a jury can value those at really whatever they want to. Like there's no specific constraint on that. The third kind is punitive damages, bad faith actor kind of damages, where someone has done something like in a really shitty manner, and those are hard to get, and because those are punitive in nature, so they're not restorative in nature. Specific damages and general damages are designed to return you to the position that you were in before the harm. Punitive damages are that person's a bad person, very hard to get, and those are designed to punish. And because they're designed to punish, the Eighth Amendment kicks in, and the Eighth Amendment kicks in such a way that the Supreme Court has basically said that somewhere around 10% is the maximum that you could constitutionally do, and that I'm sorry, 10 times, a multiple of 10. So if you have $5,000 in special damages, that's actual receipts. Maybe the jury will award you $20,000 in general damages. Maybe they will, maybe they won't. Who fucking knows? And that means that maybe you have $25,000 of restorative damages, and then at most you get another $250,000 in punitive damages, right? So what is your case worth? Well, generally speaking, who fucking knows? You get 10 different attorneys, and you put 10 different attorneys around a table, and you show 10 different attorneys your case, and 10 different attorneys are going to value your case at 10 different amounts. So, I mean, if attorneys can't agree on a specific formula for calculating damages, I don't know how you can. So what you do as a plaintiff is you say, okay, attorney, here's what happened to me, and the attorney will then, number one, write a demand letter. The purpose of a demand letter is to try to get them to make a counteroffer. You're gonna try to go as high as you think you can do without basically telling them that you're unreasonable, right? Because you want them to send you a counter. So you send, you think, your attorney says, I think you have about $100,000 in damages, so I'm going to offer, I don't know, I'm going to make a demand for $200,000, and then I'll let them try to work me down to 100, and they get it. And what you're hoping is they're going to give you a response back like, no, you don't have $200,000 in damages. I'm gonna counter with an offer of $50,000, and then you hem and you haw, you kick the tires, and you try to get it down. If that doesn't work, if you aren't able to settle it, and 99% of all cases settle, so it's probably going to settle. If you can't settle it, though, that means that you and the defendant, not your attorneys, but you and the defendant, don't have an agreement on what the damages are. So you're going to trial. And what you're doing is basically you're handing it over to a third party, either the judge or the jury, to make that valuation for you. So you're going to lay out all the facts, or your attorney's going to lay out all the facts, showing the liability, showing the amount of damages that you think you have. Here's all the receipts. Here's the doctors come in to testify, this, and that. Here's you getting up on the stand saying, oh, woe's me. I wasn't able to carry my groceries in. I wasn't able to have a sexy time. My foot hurts every time I walk more than 10 steps, whatever. And then they're going to get on there, and they're going to have their expert, and their experts going to say, well, he had this pre-existing injury already. So, not all that is from us, et cetera, et cetera, et cetera. So what you do is you sue for the most you think you can get. The only reason to even put damages, the actual specific dollar amount, in the lawsuit is because you have to give the defendant notice. If you don't put damages in there, if you just say according to suit and you win a default judgment, then the maximum that you can receive is $0, because $0 was mentioned in the complaint. So you put an amount in there just so that if you do get a default, then you can get a default judgment for some amount up to the amount that you mentioned in the complaint. So there you go. Yes, exactly. What is going on with? I don't know. Could you at least give us 10 seconds of background? What was receipt for? So she went to a. This is somewhat fuzzy. She went to a court. I think she might have had a hearing there that day or something, and she didn't go through the detectors or anything like that. She stopped on the other side and she was recording or something, and the security, the sheriff, they started hassling her or something, and they're like, well, you got to leave. So then she leaves and she goes outside and she's filming from the sidewalk into the building, and she's filming people that are going by, and then one of the officers comes out, and he's like, you're gonna respect my authority, and he demands ID, et cetera, et cetera. He takes the phone, he takes him inside, forces her to ID, etc. And so that's what this suit was for. And yeah, so I hope that helps. If it doesn't help, let me know. What if someone on YouTube hurts my feelings? Goes, much money can I sue for? Probably not anything. You have to show duty. You have to show a breach of duty, and they don't have a duty to respect your feelings, generally speaking. She had a camera in her bag and security wouldn't let it through, so she went out and started. Yeah, something like that. Thank you. Someone who is smarter than I was. And hello to you, Chris Collins. All right, back to this.
Berquist voluntarily dismissed her lawsuit on March 30th, 2022. Unless
March 30, 2022. Yeah, that's the date. Yep, that's the date.
Berquist herself provides us with any case documentation proving otherwise, any claim that she received a monetary settlement is a complete and entire fabrication. The lower court.
Well, no, it's unproven. It's not a fabrication. I don't know why he thinks that you have to prove. If you don't prove something, then it's a fabrication. That's kind of fucking weird. But again, there is almost certainly a non-disclosure agreement inside of the settlement. So, like it's a fucked up position for Mark to put pink camera magic in, because it's a Kafka trap. Not like Josh, who misunderstands Kafka traps all the time. I really do like Josh. I very much like Josh. I wish I was watching his stream right now instead of responding to this fucking idiot. But needs must, as they say. But this is a real Kafka trap, because he's saying that she has to show proof, and he probably knows, or he probably suspects that she is prohibited by the terms of the settlement agreement from showing proof. And there's probably some sort of enforcement mechanism in there where they could come after her for money, etc., attorney's fees, yada yada, if she does. So it's a real dick maneuver by Mark Stout. He's just a terrible human being. I mean, one would fucking expect someone who's done time in prison to be a terrible human being, but I mean, he certainly doesn't break the mold. He sets the mold.
Courts awarded the defense over $5,000 in attorney's fees because Berquist's lawsuit was frivolous. The defendants probably warned Berquist that her appeal was also frivolous, and the defendants will probably be awarded further attorney's fees if Berquist lost her.
What are all these fucking probablys he's got going on here? The defendants probably. So, like, she's got to fucking prove everything. She's got to prove fucking everything. And he could just go probably. The defense probably warned her that her appeal was frivolous, and the defense would probably be awarded further attorney's fees if Berquist lost her appeal. The defense probably scared Berquist into the agreement. I don't fucking think so. Here's a fun little tidbit. Berquist is probably judgment proof. She's probably judgment proof. Does she own a house? Does she have $15,000, $20,000 in her bank account? She doesn't look to me like someone who's making that kind of money. You know, what is her social blade pink camera magic YouTube? They show in here somewhere like probable earnings, right? Here we go. Well, there you go, folks. Her estimated yearly earnings are somewhere between $700 and $11,000. So she's probably not. She's probably judgment proof. Like, you know, a judgment is great. One attorney that I work for has a file full of judgments against people. You could buy judgments. I mean, people sell judgments all the time. Why do they sell judgments? Because they know they can't fucking collect them, and they'd rather get like 40 cents on a dollar and get actual money than to gamble on getting the whole thing, right? And you can buy judgments really cheap sometimes. Like you can buy them at 20 cents a dollar, 10 cents a dollar. I mean, it can be really fucking cheap to buy these things because they're hard as fuck to collect. And judgments don't last forever. In California, most judgments, certain judgments are exempt from this, like judgments for child support and things like that. But most judgments are good for 10 years and you can renew them once, which means at most you can maintain a judgment for 20 years, right? So let's say if someone even owns a house, like let's someone owns a $500,000 house and you get a $15,000 judgment. And the first mortgage on their house is like for $300,000 and they have a second for another $50,000. So those are prior to you. So you got your, let's say you got a $50,000 judgment just to make this fucking happy scrappy. So there's $350,000 already in against the house debt. So if you wanted to sell the house, you'd have to pay off the first and the second. You have to pay off $350,000 to be able to sell the house. So they don't do it. And is it going to get paid down enough that it's going to make it worth your while to do? Like, judgments are fucking hard to collect. And that's if someone has a house. And there's federal limits on how much you could take from someone's wages if you try to garnish them. And if they're not getting a steady paycheck, or if you don't know where the fuck they're working, that makes it all the more difficult. Probably twice a month, I'm in a debtor's exam where I have to, I've asked the debtor to produce these documents. They're required by the court to produce them and answer my questions. And, you find out where their bank account is and they show you. And then by the time you get a fucking bank levy filled out, done, sent off to the sheriff, etc., they've already closed that fucking account and moved any money they had into a new account. And you're back fucking guessing again. Like, she's probably judgment proof. People like, get attorney's fees against Chile. Get attorney's fees against Chile. Like, Chile's also fucking judgment proof. Like, any debt against him is not worth the paper it's printed on. He's judgment proof.
Review. The defendant probably scared Berquist into the agreement. Berquist herself admitted in one of her videos that her lawyer, quote, filed a motion for decision, basically, and what they decided is they were going to drop the case, end quote. Berquist
And what they decided is they were going to admit it in one of her videos. Their lawyer. Okay, which case? Which case? She's had multiple cases. She filed the motion for decision. What the fuck does that mean? Her lawyer filed the motion for decision. Hold on a second. We can do this. We can do this. All right. Filed a motion for decision. So I don't even see that that they filed their opening brief. They didn't even file an opening brief. So and there's no motion for decision. There was a motion. Well, I guess there was a motion to dismiss. So what the fuck is he saying? Basically, what they decided is they were going to drop the case. She admitted, he got her to admit it in one of her community posts. We agreed to settle the matter outside of court in exchange for dropping the appeal. Yeah, that's the way it works. We agreed to settle the matter in exchange for me dropping the appeal or dropping the lawsuit. That's the way it fucking works. That's how settlements happen.
Admitted one for community page posts. Quote, we agreed to settle the matter outside of court in exchange for dropping the appeal. Unfortunately, I cannot discuss the terms of our agreement publicly, but I am happy with the outcome. I'm also happy that this 4-year ordeal has finally come to an end, end quote. Berquist.
So now he fucking knows. He fucking knows there's a non-disclosure agreement, and he's still demanding. He gets to make up shit about probably this and probably that, and he demands that she show shit. And he admits he fucking knows that she can't. He admits that he knows she can't. Hard to collect anything. Exactly. You can't squeeze blood from a rock. You can't be exploited if you take your case to a set of lawyers, then sign an agreement with the one you like best to argue your case. You could like, just because you like an attorney, people make most of the decisions that they make in not on a logical basis, but on an emotional basis. I worked in sales for a long time, and like people, if they're going to buy a house, they go out and they look at houses. They find the house that they like. They don't have any real logical reason for it, and then they will backfill. They'll literally backfill reasons for why that's the right house. And people do that with lawyers too. Just because you like someone doesn't mean they're a good lawyer. It doesn't mean they're a good person. It doesn't mean they're honest or ethical or anything else. It just means you like them. I mean, have you ever liked someone and they turned out to be a piece of shit? Have you ever disliked someone and then realized that they're honest and ethical? You know, a lot of people don't like me, and that's fine. I don't need to be liked. I don't want to be liked. Most of the people on here who don't like me, I wouldn't fucking give two shits about in the first place. So, like, I don't. Who the fuck are you to not like me? I don't care. But can you say that I'm not honest and ethical? I don't know. Maybe you can, I guess. But when you've got nothing, you got nothing to lose. There you go. How does a judgment relate to the wrong alleged? Well, the wrong alleged would be the breach of duty, breach of duty, and then so you have to show duty, breach of duty. Then you have to show causation, like how the breach of duty caused damage. And then you have to show the damages. And so that's how you did this bad. You weren't supposed to do this bad. You owed me a duty. You weren't supposed to do this bad, but you did this bad. It somehow caused me harm. There's a relationship between the bad that you did and the harm that it caused. And this is the harm. So you owe me that. That's how it relates. I hope I explained that well enough. Yes. For every debtor's exam, well, number one, I don't go to the debtor's exam for free. And number two, there's a motion to file them. Murphy's just jumped in. Did Stout give the case that his memo was used in? I don't know. I haven't got there yet, brother. Probably not, because any fucking attorney would be laughed out of the fucking courtroom if they tried to use a memo written by a fucking prison litigator. Because like he cites cases in it that are probably going to get cited by an actual attorney in an actual lawsuit. But like he has a shotgun approach where he takes cases from all different circuits, from all different levels. And, you know, like I have shown in previous videos, like the First Circuit treats the right to film police in public as a different thing. Like it's not limited to the traditional public forum, but for example, the 10th Circuit, it is literally a traditional public forum test. So two different circuits are handling it two different ways. You got to get the right cases from the right circuit. So attorneys might use the cases that are in the memo, but they'll never use the memo. Can't squeeze blood from a rock, but you could get juice if you squeeze me. Ooh, talk dirty to me, tomato. He needs to insulate his mom's shed. He's all bundled up and he still looks cold. Well, you know, I guess the return on your contingency agreements when you're a pro se litigator aren't high. His quote legal memo end quote. Yeah, fucking retarded. Like what he should do if he really wants, like if he wants to get his memo into these cases, he needs to file a request with the court to file an amicus brief. amicus brief, however you want to say it. That's the only way he could ever get in. And show me where he's done that successfully. Oh, well, thank you, Raimondo. I will disappoint you sooner or later, I assure you. I used to like coded law. Well, I'm sorry. You know, he probably can't help it that he's a piece of shit and a liar. But the veil can only last for so long. Your insides will show sooner or later. And that's what I'm saying. Like, you know, you meet an attorney, he's putting on a song and dance for you, and then like when it comes down to it, like, is he really gonna to do what needs to get done? I got an entire $1 in my class action suit against Milli Vanilli. Oh wait, I mean my friend who bought the Milli Vanilli. I got $1 for that suit. My friend, nice. I kind of like you. Well, let's not get too serious. I don't not like you. Well, that's fair enough. Duty. Oh, Burb, I like you. I don't hate watch. Don't agree with you on everything, nor do I anyone, nor should anyone, but I trust your legal perspective to be fairly unbiased. Well, thank you. I'm not a jail or a prison attorney, so, you know, I come at this from a disadvantage. Mark's memo is great word salad. It's not case law, it's coleslaw. Well, I think I read it once, and it was just a jumble of citations that didn't really make a lot of fucking sense. Like, it certainly did not cut to the chase. In order for a typical memo, a memorandum of points and authorities, or a legal memo, memorandum of law, will, number one, set out the facts, number two, set out the law, and number three, apply the facts to the law, or apply the law to the facts. And that'll get you a conclusion. Rule, issue, analysis, conclusion. You know, that's what they teach you in law school. CRAC, conclusion, issue, analysis, conclusion, or IRAC, issue, rule, analysis, conclusion. What you're trying to do, because the court is dealing with two things. It's dealing with facts. There's a finder of fact and there's a finder of law. And, you know, our big-brained legal scholar, Stout, can't fucking wrap his little tiny brain around it because he hasn't been trained to, and he's probably not smart enough to do it in the first place. Because, like, dude, go to law school, bro. Go to fucking law school, get your fucking law degree, pass the bar. Pass the bar. Then you and I will be on equal playing fields, right? And then you'll have a basic understanding of what you're fucking talking about. So his memo, it's not case specific. Like, if read a fucking opinion, or a memorandum opinion by a magistrate judge, or well, sometimes the orders don't have it, but like if the district court judge is going to make a final decision, he'll have the facts. The memorandum opinion from the magistrate will always have the facts, the law, and the application of the facts to the law. It'll always have that. An order from the district judge, unless it's just adopting the opinion or doing something else where that isn't necessary, it will also have that formula. Most appellate briefs will also have that formula. Even Supreme Court cases will also lay out the facts, what the Supreme Court considers to be the pertinent facts. It'll lay out the law, and it'll apply the facts to the law, or the law to the facts. Duty. I don't like people not like you. I don't understand that. Would someone please explain what a circuit is regarding U.S. courts? Circuit court, usually, generally speaking, some states will have circuit courts, and, you know, fucking you can get a million different versions. But normally when someone's talking about a circuit court, they're talking about one of the circuit courts of the United States. Federal circuit court, that's the appellate court. So you have the district court as a trial level. Then the circuit court is the court of appeal. And then the Supreme Court is above that. So that's what a circuit is. And so the U.S. is broken up into, 12 circuits? There might be 13. I don't fucking know. I think it's 12. So California's the Ninth Circuit. California, and, well, the Ninth Circuit's huge. It's like most of the West. Fifth Circuit's Texas, and Texas, Louisiana, and Mississippi, right? Yeah. He can cite cases, but has no ability to extrapolate from them to encompass other cases. Well, he'll kind of, but it's a weird. It only if it would work in his favor, because he took Sheets versus the city of Punta Gorda, where the parties agreed that the city hall was a non-public forum. It was a limited public forum. That's what their agreement was. They agreed it was a limited public forum, so that the trial court never made a finding of fact. Was there a motion to dismiss? It was some sort of a motion to dismiss or motion for summary judgment. So there has been no finding of facts. The court is just basing this on the the undisputed facts, and if there is a dispute to the facts, then it would be based on the plaintiff's best foot forward facts. And so the parties agreed to it, so that there was never a finding of fact by that court that the city hall was a limited public forum. But he's still willing to extrapolate from that. There's no finding of fact there, to every fucking city hall is a limited public forum. Murphy said he filed a brief in LIA's New York case. Okay. Did he get permission to file it? And so normally the process is you seek permission from the court to file an amicus brief. And the court will then make a determination of whether or not the court would think it would be helpful for you to do it. I'm surprised. I'd be shocked if a court decided that Stout, pro se litigant, would have anything useful to say on the law and would allow him to file an amicus brief. So, I mean, we saw, what was that? We've seen other people try to jump into cases. There was someone who tried to jump into Chili's case, right? Hold on a second. Let me let's do this. This was Castro versus LVMPD, right? Is it Castro versus LVMPD? Who was it? Somebody tried to jump in somewhere. Yeah. Oh, here you go. Yeah. So this fucking Jason Jensen filed a motion into Chili's case, and it was denied, etc. Motion to reconsider. Well, not that one. Is this one? Jensen's motion for joinder was denied, and his other. So yeah. So I mean, just because you actually managed to file into someone else's case doesn't mean that you did it with the authority of the court, with the permission of the court. Like that, dude. Yeah. So, yeah. Great minds think alike, and us too. Criminal case. Oh, he filed. He filed the fucking brief. Oh yeah, I'm sure the court. I'm sure the court reviewed it. I know the court did not review it. Court is divided up geologically. Geologically. Got a hangnail. Each region is a circuit. Yeah. Geographically, but yeah. He just sends his legal memo to random prosecutors, but remember that time he tried to rep a woman only to be told that would constitute practicing law? Pepperidge Farm remembers. I remember something about it, but I don't remember the actual specifics of it. He doesn't take up very much space in my brain at all. Iraq or C-Rock, yeah. See, Alpha Fox Adam, he graduated law school. He's going to take the bar soon, right, brother? Like, you don't take up much space in my brain either. But I remember you graduated law school and you are set to take the bar soon. And I hope you pass. And he's over fucking, He actually, I have seen, he has sent me a picture of his diploma, degree, whatever, his JD. Does Mark still take payments for his services in honey buns, ramen, and cigarettes? I mean, I like ramen. I'm not a big fan of honey buns, and I'm not a smoker. I like people just like you. Well, thank you. You mean human? He did file an amicus curiae brief in the LIA case for injunctive relief against New York Police Department. Again, just because you filed something doesn't mean you have permission from the court to file. There we go. Do we need more SCOTUS justices for the number of circuits? Opinion, obviously. No. Each circuit has a Supreme Court justice assigned to it as the head Court of Appeals judge, and in that role, they can actually take cases on the appeal level. I think. Now I'm second guessing myself. I think they can take cases and actually hear them. Like that single Supreme Court justice can take a Court of Appeals case, a circuit court case. But generally speaking, what they use that is to recommend things to the whole Supreme Court. Injunction motion for sheets. Oh, but anyway, yeah. But it wasn't at the fact-finding stage. It was a non. There was no finding of facts. No finding of facts had been taken, had been done. It was at a stage in the pleading where the court was looking at undisputed facts, and then the rest of the facts would be taken to the light most favorable to the non-moving party. It's unproven, so it's probably a fabrication. Yeah, like the law of gravity. Okay. He dismissed voluntarily after losing the injunction. Yeah. It's like, I understand the limitation of Sheets versus the city of Punta Gorda. I've done videos on it. The facts aren't really that important to me, procedurally where it was at. The important thing was the analysis that the court did. When you look at the way the court applied the facts that it had, not as findings of facts, but these are the facts that we have to work with, and here's the law, then that works out well. Like you could make it so you could make a best guess of your ability to win in a certain situation. So you could do an analysis of the Sheets case doesn't give you the how to do the analysis of what a limited public forum is. I think it like broad strokes it, but you could look at a city hall and you could be like, okay, well they don't have a free speech zone. Okay, so all right, and but they do have like a board that they allow you to put up like help wanted posters and things like that. Okay, so it's probably a limited public forum because they're only allowing limited kinds of speech, right? You can't go in there with a bullhorn and start, repent for the day of reckoning is near. You can't do that, right? So it's probably a limited public forum. Okay, so now that I know that, then I can follow Sheets like a freight train and get there, right? 12 number of circuits. Yeah, 13. Okay, whatever. I was fucking close. I don't really need to know all of them, yeah. Conjunction junction. What's your function? It's on the part of the filings. Okay. Jensen something. I don't know what we're talking about. Stout, Stout, and Stout. Sounds like a pub lawyer I know. Oh, I used to love Stouts. I'm not a big fan of him anymore. Stout filed his amicus brief in LIA's civil trial without requesting leave to file, and the clerk misfiled it as coming from LIA and left it on the docket. Oh, that makes sense. So there's your explanation. Yeah, good fucking job. Good job. Good job to the clerk. Clerks suck. Hashtag none. That dude was whack. Oh, Jasper, I thought it was his misdemeanor case. My bad. Oh, is it okay? All right. Okay, now I understand. So he filed the amicus brief in LIA's civil trial without requesting leave to file, and the court misfiled is coming from LIA. Okay. You got to wait all the way till February to take your bar exam, my brother? Well, good luck. Reviewing contracts this week. Oh, contracts. You know, it's fucking hilarious. That shit, like the shit you study for the bar exam, like you fucking wake up in the middle of the night and you're like, rule against perpetuities. Fuck, what was the rule against perpetuities? Just having a fucking hot flash about dumb shit. Like you'll never even, well, I mean, maybe if you get into probate law or something like that, wills and trusts, whatever. Today was the deadline for the soft sit in my appeal case to file his brief convincing the appellate court that they have jurisdiction over his appeal. They didn't file one. I'm slightly disappointed. Well, you know, if you like that kind of thing, reading soft sit stuff really just gives me a headache. In sheets the ordinance. Well, yeah, but it doesn't necessarily matter that there's an ordinance. The ordinance, you could still extrapolate from the chain of reasoning that the court did to see how the court is going to look at ordinances in general, at restrictions on filming in general. So the specifics of that aren't nearly as useful. The language of the ordinance. I don't think they challenge the ordinances being like facially unconstitutional or anything like that. Facts are the things that clearly are obvious. Okay, the ordinance stated that it was a limited public forum. Well, that doesn't matter. It doesn't matter if the ordinance stated it. The government doesn't get to, like, the government can open up a forum to be more than what it is. Like the government, Vandenberg Air Force Base, the government took a section of that non-public forum and said, ta-da, you are now a free speech zone. Traditional public forum in this little box, right? But the court or the government can't like write an ordinance saying that the street corner, that the city sidewalks, the court can't write an order saying the city sidewalks are not to be used for solicitation or handing out pamphlets or panhandling. I mean, the city could do that, but that is starting to get. Well, hold on a second. The sidewalks are a traditional public forum. The city can't say that sidewalks are now a limited public forum in an attempt to try to do these things to limit it. The court's going to say, whoa, like, I don't fucking care that the sidewalks are a traditional public forum. I don't care what you're trying to do, city. Like, you could call a sidewalk a limited public forum all you want, but that sidewalk is a traditional public forum. Even in grace, like the fact that the United States Senate had this bill that was going to restrict what you could do on Supreme Court property. Just the fact that the external sidewalks around the Supreme Court property, even though that was technically Supreme Court property, but it looked and functioned exactly like a normal sidewalk, that it was unconstitutional. Even though the Supreme Court grounds themselves are probably non-public forums, or at best limited public forums, still the surrounding sidewalks, even like, nope, sorry, like, you can't do it. Merb isn't a liar like Coded is because he has no pants on that could be on fire. Well, actually, if I was wearing pants, would they be on fire? That's the problem. Or maybe I'm not wearing pants because they keep catching on fire. That's how I was before taking my NCLEX. Well, I took my bar exam, in 2017? Yeah, I passed my bar exam in 2017. And then I had to take, so in like February of 2017, I took and passed the bar. And then in like June or July, I took the MPRE. And then when I passed that, I wasn't expecting to pass any of it. So like each time I'm like, oh shit, I got to do the next thing. And then when I got done with the MPRE and I found out I passed it, then I was like, oh shit, I got to do the background thing. And so that's why it took me like a fucking year after I passed the bar to actually get my license. That is an excellent observation. How could he be a liar if he has no pants? Well, I don't know. Rule against perpetuity. Say the perpetuities aren't allowed. That's true. Okay. Where there's smoke, there's fire. All right, so we're caught up on that. All right.
It's never claimed that she received any monetary settlement. And folks, that's my point. There's a difference between the frauder getting paid and the lawyer getting paid.
Yeah, so she never claimed that she received any monetary settlement, literally because she said that I cannot discuss the terms. One of the terms would be that she received money. She can't discuss that. I can't discuss the terms. She never discussed the terms, and therefore she must not have received the money. Like, you fucking idiot. Like,
there's a difference between the frauder winning a case and a lawyer exploiting the frauder's case. There's a big difference. Listen, lawyers are powerful.
There are bar associations that are designed with rules of professional conduct to prevent lawyers from exploiting cases. So, like, I don't know what you're talking about, dude. Like, if and again, only Amanda could accept the settlement agreement. Her lawyer could not. Only Amanda could accept it. Her lawyer could not. Only Amanda could accept it. Her lawyer could not.
Powerful people, they can achieve a lot, folks. Folks, let me emphasize to you, lawyers can do a lot. They can get away with a lot.
Except we're really fucking highly scrutinized. And unlike most professions and most people, if the state bar investigates me, if they're like, you know what, I want to investigate you, John. You know what I have to do? I have to fucking comply with everything that, like, if they say, turn over all your fucking files, you know what I have to do? Here you go. Explain why you did this. I can't take the fifth. If I want to keep my license, I have to be like, okay, here's exactly what happened, and here's what I did, and here's what I thought, and here's why, and blah, blah, blah. I have to do that. I have to assist the bar in investigating me. Fucking this dipshit, Frauders Exposed, Mark Stout doesn't have to, like, if he gets investigated for practicing law without a license, he can say, you know what? I'm not going to say anything. I'm not going to assist you. I'm going to shut up. I'm going to invoke my right to remain silent. I'm going to demand an attorney, and you can go fuck yourself. Get a warrant. I have to be like, here's all my files. Oh, you know what? You know what, John? We want to see your bank account, your trust account. Well, here you go. Here's all my trust account information. You know what, John? It seems like there's a penny missing from your trust account. Can you explain that? Fuck! No, I can't. Shit, what did I do wrong? I had opposing counsel. I had opposing counsel on a case, family law case, surprisingly enough, because I am just a first-year family law attorney. I had opposing counsel who lost her license to practice law for like 2 months because you have to settle up your trust account every month. You have to like make sure it's fucking spot on. And I guess she didn't do it. And they audited her and they're like, show us what you got. And it was some pitiful sum of money, or at least according to her. And they're like, okay, you can't fucking practice law. You gotta fucking, they went back to like 5 or something years. Like they went back a long ways. I don't know exactly. She's like, they went back all the way to the beginning. I think she'd been practicing like 5 or 6 years. She's like, they went all the way back to the beginning. They looked through they made me get all of my account statements and show everything. And I mean, it's like the state bar can and will crawl up your fucking ass. We don't get away with a lot. We shouldn't get away with a lot anyway. Lawyers are powerful. Yep, I took Latin in college for the witchcraft, not just for the law. I mean, that makes you a better lawyer than me, Paul, because I failed witchcraft. Sorry. Captain Clown agreed. Sometimes there is smoke without fire. Sometimes there is fire without smoke. Hearing Stout talk again is reminding me of that debate you two had. You laughing in his face, seeing Goodell anger. You weren't taking him seriously. Like there was nothing to take seriously. He was like, let's extrapolate sheets to every city hall in the U.S. I'm like, well, what if a city hall is? Well, I can't talk about hypotheticals. So you could extrapolate sheets out to every single city hall, but you can't discuss like the individual details of what that city hall, what would happen if these. No, I can't do that. Like, then what is there to fucking discuss? There was nothing to discuss. Fire without smoke is my next garage experiment. I thought that was going to be your next garage band. We didn't start the fire. It's always been churning since the world's been turning or something like that. Oh, shit. That's like Fight Club. We weren't supposed to talk about that. He's right. He's right, Paul. We need to go whack our peepees or something like that.
Okay? That is why I broker with them regularly. Okay? That is why.
Wait, he brokers with lawyers?
People, they can achieve a lot, folks. Folks, let me emphasize to you, lawyers can do a lot. They can get away with a lot. Okay? That is why I broker with them regularly.
What the fuck does I broker? I broker with lawyers regularly? What the fuck does that mean? This guy just spitting out bullshit. And I guess he has people in his chat who are eating it up. Congratulations to them.
Okay? That is why I am on friendly terms with lawyers. All right? They can do a lot of things that nobody else, especially a frauder, ever could. They can get away with.
My dad had Wells Fargo mess up his IOLTA account. IOLTA is interest-only lawyer's trust account. So much like ATM machine is a automatic telling machine. IOLTA account is a interest-only lawyer's trust account. So there you go. The Bar Association asked him about having, so well, Wells Fargo did. They said, yep, that sounds about right, and didn't do anything. Well, that's fucking pretty cool. I mean, if they actually did it, but if you accidentally paid another client money that wasn't that client's, or if you paid yourself money that wasn't yours, apparently it gets a little fucking hot. Apparently, at least in California, they do not fucking play around with that. Sovwarts is the word. Hypothetical. Nice. I think copyright troll lawyer Richard Leibowitz got caught doing the same thing with his trust account in the Southern District of New York. Well, if that, I mean, ex-copyright lawyer at that point, like what? An electrical engineer can do a lot of things other people can't. That's true. Is that not why we have the ability to appeal in criminal cases for insufficient representation when an attorney does not represent their clients to the standards of the profession? Yes, because sometimes attorneys are shit. What can they get away with? I don't fucking know. This is his hypothetical. Let him fucking explain it. He's just saying you need a PIN number to access the ATM machine. That is true. Speaking of which, an IOLTA account, at least in California, you can check your balance in the IOLTA account, but you don't get an ATM card for it. You can't do anything with it. You can't transfer funds in or out of it. Everything has to be by check. So you write a check out of the account. And so like, I mean, and you can't have like you can only put enough money in there to fucking pay any, like if there's a fee associated with it, you have to put your own money to pay the fee. Like if there's some sort of like a bounce check fee or whatever, you have to put your own money in to pay that. But otherwise you can't have your own money in there. So like as soon as you pay out, your money has to come out. You can't leave your money in there. That's commingling. I mean, they're fucking strict as shit on attorneys. They get away with knowing what they're doing in the legal system, which is why they're lawyers. Well, that is generally speaking, not always, but generally speaking, true. Attorneys can also be retards. That is also true. I know Mark never provides concrete examples. Such a weirdo. Well, if you never provide an example, then you never have to defend it. And his fucking I don't know what you call them, like frauded or fuckwit lickers in his chat. They just eat it up because he's telling them what they want to hear. If anybody's telling you what you want to hear, be suspect. Be like, hold on a second. You're telling me what I want to hear. Are you a salesman? Are you going to benefit from this? You know what? I don't benefit from this. I don't monetize this shit. I don't sell anything on here. I don't benefit. So if I'm telling you what you want to hear, well, then apparently you just want to hear what I have to say. But what's Mark? Is he monetized? Is he selling something? So that is a problem. And then your dad paid it to make it up and everything was good, right? Brad Trek, the 1900s called. Well, I mean, you got to leave that paper trail, baby. Sorry I missed the Mark Stout Clown Show. Can't wait to catch the replay, even though listening to Bird right now makes me want to blow my own nose. I'm so sorry. How small is your G-string account? You'd have to buy me dinner to find out.
Doing things that nobody else can get away with, folks. Okay? But remember, it's the attorney. And that is all the difference in the world. Okay? There's all the difference in the world between...
Yeah, there's all the difference in the world between the attorney and the client. The client controls the goals of the litigation. The attorney can figure out how to get there, but the client is in complete control over what settlement offers to make and or accept. The attorney has no power there.
Between an attorney and a frauder. And that, you know, I see the comment about Merv, Stephanie. Merv is probably one of the least qualified people to expound upon civil rights litigation. He's never been a plaintiff or defendant to any civil rights cases. He's never litigated any.
That's true. I've never been a plaintiff or a defendant to a civil rights case.
Any of them. He's certainly never won any, and he's...
I've never, if you want to say litigated as in taking it to trial, I've never done that. No. If you want to say won as in gotten a settlement, well, I also signed a non-disclosure agreement.
Certainly never litigated any settlement. Okay? He has...
Litigated the settlement? That's fucking weird. That's like fuck your way to virginity? I guess technically, I mean, you might call it like you negotiate to a settlement. But again, you know, non-disclosure agreements generally bind the attorney and the client, at least in my experience. So
zero experience, none. So it defeats the purpose. It defeats the point.
Well, let's just assume arguendo that I have not done any. Let's just assume that. Let's give him the benefit of the doubt. I have gone to law school, which gives me training on how to do it, right? And I have passed the bar, which means that California thinks that I'm qualified and capable of doing it. Fucking crazy. Fucking crazy.
Being a lawyer. And he admits he's a 1-year divorce attorney or something. He admits that.
Yeah.
He admits that he doesn't know anything beyond what he practices.
Hold on. I never said I don't know anything beyond what I practice. And you know, take it from a pea brain like Mark Stout. I mean, it's just like common fucking sense, bro. Like common fucking sense. When did we debate? Didn't we debate like a year ago? And I use the word debate very loosely. Like, how? Like this is me. There's my work address. There's my work phone number. This is my email. I am an attorney. My name is John Emerson Rietveld. My state bar number is 320086. I was admitted to practice law on February 20th of 2018. I've been licensed to practice the entire time. I've never had any disciplinary action. Like what in me being licensed for the last 5 years and change, almost 6 years. What about that would make you think that I'm a fucking first-year family law attorney? Fucking Christ. Tom Girardi. Oh yeah. God. Yeah, he was the one who started it all. He was an attorney from Southern California, I think. I didn't follow a lot on it, but yeah, there's Tom Girardi. He was colluding with state bar people. Yeah. The state bar is all fucking hot to trot. What? Practice doesn't make perfect. It's stout, but he'll keep trying until the magic words run out. Yeah. I do have a bar number and everything. Lower midwit. He's not even a midwit. Stout is not a midwit. He's not smart enough to be a midwit. Fuck your way to virginity. Exactly. First year family law baby. I mean, it's literally a joke, but I guess he's so fucking stupid that he takes it as true, even though he should know, because it was over a year ago that we quote debated. Yeah, he really is stupid. I have a bar tab and everything. Well, don't tell that to Coded. He takes that first year family law attorney thing seriously. Apparently, he fucking does. Wait, so if you happen to agree with Mr. Stout, would he take the same position? Well, attorneys are really fucking powerful and really fucking smart, and they own frauditors, and he files frauditor lawsuits for himself and his family members. So I'm smarter than he is because I'm an attorney. But wait a minute, he played the Uno reverse card, and so he's actually smarter than me because he's filed frauditor lawsuits and I haven't, or something. I don't know. Yeah, it was fucking bad. One of the funny Stout videos from when he was still a frauder, known as Legalized Drugs, is on Hanbin's channel from like 2 years ago. How many first-year families need an attorney? Well, all of them, apparently. He smoked all his brain meats into perpetuity. Yes.
So I can't credit him. Does he know about probably the law that he practices? Probably knows everything about it. I probably know nothing about. He probably does.
Do I know everything about the law that I practice? Well, currently, in my private practice, I have one personal injury that's ongoing. I've got two they're actually contractor contracts cases going. And then I've got a bunch of family law. And then in my work as associate counsel for another law firm, I've got a contract case and I've got a family law case. And then in the other firm that I'm associate counsel for, I've got fucking bazillion cases going on. And do I know everything about all the cases? I mean, for that firm, I've got contracts cases, I've got personal injury cases, I've got medical malpractice cases ongoing. I don't currently have any civil rights. Hold on a second. I have a civil rights case ongoing in that one. Several family law cases. Is a general practice attorney. You get a lot of general practice.
But he doesn't know. He's not a civil litigant. He doesn't understand civil litigation. See, there's a difference between being.
I'm not a civil litigant. I don't understand civil litigation. Actually, oh shit! I've got a criminal attorney over on that from that attorney as well. I do mostly civil. I do almost all civil. Civil would encompass family. Oh, I've got probate cases. I've got one guardianship. And I've got 3 estates. Hold on a second. Back up. So I do mostly civil. The only criminal I do is very rare, and I've only done misdemeanors. So, and I haven't taken any of those to trial either. So how about that? I hear that attorneys are good looking and good at the sex also. You've been lied to. I think we should all ID ourselves on the high wit to no wit. Identifies upper nitwit. Nice. I used to scrape all of Stout's videos, but I realized he was dumber than Chili, so I stopped wasting the drive space. Well, I'm sorry. He's so dumb that he's a human parody. Yeah. You win the chat today. Yeah, that was good. Oh, and Coded took my wrench over that boosted audio video. I was his first wrench. Ha ha ha. I thought he had thick skin. Well, you shouldn't have fucking told him that you boosted the audio on that. Like, I wouldn't have said shit. I didn't say who did it. So, it was your dumbass telling him. He's as thin-skinned as the rest of them. Well, I mean, he'll tell you that it doesn't bug him. He'll lie to you. If you have the ability to read and comprehend what you read, then you are capable to speak about things. Having the law degree does say you have the knowledge to break down the legal principles. Well, not necessarily. Not necessarily. When I first started practicing law, when I brand new, when I was actually a first-year family law attorney, because the the law firm that I started working for started using me almost 100% used me for family law at that time. Like, I didn't know shit. And like, you get something fairly basic and you need to know like how to fucking like, you need to know how to think about it and start researching to find the cases that actually deal with it. So it's kind of like you have to know what to ask, and you have to know enough to know what to ask, to know what to read, to know what to get the answer for. So it's a little bit more complex than that. Just so you know, like he reads cases. Like there was one case that he read. Let me do this. There's one case he read. It was this case. Oops, this case right here. So this case is he says that recording inspection of private property does not fall within this category, right? And so he thinks what that means is that you don't have a right to record public officials performing public duties, even on the individual's own private property. But the court wasn't making that distinction. In this case, they were doing an inspection, and they had the right to exclude and not allow him to be there filming while they did the inspection. Because essentially, while they're doing the inspection, it is not really your space anymore. They have like a right to be there. They have possession, for lack of a better word. And so he's extrapolated this one instance where inspectors are going in to do a health and safety inspection or test. It was a dry cleaning plant where they actually did the dry clean, not just drop off point. And there was a contamination that was getting out, and they were going to inspect that. And so just like police can close off like a section of sidewalk or whatever for a crime scene, see, the inspectors can like, no, you can't be here, you can't film in here, you got to go back, just like that. But he extrapolated it out to shit. You can't see it because this big old fucking thing's in the way. But they extrapolated it out. So like he's not smart enough to know like what to read, if that makes sense. When that PI case settles, Merv will be flush with cash and value, sold to his place for a barbecue. Well, there's a reason why I own a bigger house now. Just saying, there's a reason why I own a bigger house now than I did with land around it. There's a reason. Stone Vet is pretty thick-skinned, though, even when you call him Stoned Vag. Josh is really a solid dude. Like, he's a really solid dude. Like, I wouldn't want to drink with him because, I mean, I think it's hilarious to watch him when he's been drinking and he's live streaming. Like, that's I like Spicy Josh. I like Spicy Josh a lot. He's a lot more coherent, but boy, he gets heated quick, and I enjoy it. I wouldn't drink with him though. I would have a drink while he toked, and that would be fun, and that'd be fine. His attempts to serve Schrodinger's cat with a lol suit were hilarious. I didn't tell him. He saw me asking for timestamp and assumed. Okay, well, I wouldn't have given it away. You should have just said, well, no, I didn't do that. Just deny. Well, Stout just gets butthurt and calls people pedo after he's blocked you from responding. Okay. He didn't validate his theories, but oh well, he's obsessed with WNN as WNN is over Chile. I mean, as long as it gives him content and as long as he entertains his audience, that's all that matters. Reading and comprehending are worlds apart. Yes. Around here, private practice attorneys can get roped into defending indigent criminal cases if the PDs are busy. Where you are, can you get roped into being a PD? No. I know some places like, oh geez, there's what, like, as part of like you're forced to do pro bono hours, and they do those pro bono hours by making you defend indigents, and that's fucking terrible. Like, any work that you make someone do is never going to be as good as work that somebody wants to do. They should just pay the private attorneys. Like Texas has a good system where like California has a system too, where you could be on a misdemeanor panel or a felony panel, and like if they don't have a public defender, if they need an outside person because of conflict or whatever, then they can call someone in off the panel and they pay them, and you don't get as good a rate of pay as you would defending a private party, getting paid by a private party, but you don't have to chase the fucking money either. It's guaranteed pay. The state writes the check, and it's all good, or the county writes a check. It's been like 2 weeks, and this is the first time I've said about anything. Okay. But if it was a long control, why would Coded demand someone or demod someone for helping spread the clip? That's kind of weird, huh? It's almost like he was fucking lying. Which is not weird because I fucking called him out on it. Weird, yeah. Yes, they are, Captain Clown, and especially on social media, critical thinking skills and common sense are not so commonplace. Well done, by the way. Yeah, the fucking clip is great. Thank you. He left the live up afterwards. Easy to boost audio. Lol. Well, then he took it down when he found out that I was asking for it or something, or he edited it out or something. He talks about Dan being in a home or living with his parents, but then his mom comes in to clean his room. Don't be talking mad shit if you're doing the same. Exactly. But I think Dan's in a council house. Someone said that he cut that part out. I thought so too. But who knows? You hear lots of things on the internet that aren't true. Yeah, it's pretty rich, all things considered. I put it in order for spare ribs. Ooh, I love spare ribs. Josh is amazing. I love that he has 0 Fs to give. Yes. I really want to drink with Josh. He would be a good time. Dude, one of two things would happen. He would get in a fight with you, or he would get in a fight with someone else, and you'd be pulled into it. Like, I don't think Josh is lying when he said that he's been in a fist fight with every single one of his friends. I don't think he's lying. I take the man at his word. I don't think Josh is a liar. So that's all I'm saying. You want to go down that road, bro? You go down that road. I ain't here to kink shame. I'm never kidding about loving Josh's crotch grabs when he's drinking. That is like the case where the teacher filmed inside the school during school hours, but just she was a teacher at the school. She needed permission to film after school hours. Okay. Yeah, I don't know if I'd drink with him. Yeah. If he was token, I'd drink while he toked. Absolutely. He's not worth the effort of an argument. Did we switch back to someone else? I love Merb. Well, thank you. I'm actually going back into the office tomorrow. Kink exposed. Josh has a history of drunken bar fights. Yep. Lord Byron, mad, bad, and dangerous to know. There you go. All right, back to the nonsense.
A lawyer and being a civil litigation lawyer. Okay, there's just a difference. Civil litigation is a beast in and of itself. And
no, there's not really a difference between them. I mean, there's even on civil litigation, there are elements to every cause of action, and it's basically the same elements. With civil rights, it's instead of was there a duty, was there a breach of the duty, was there causation for the damages, and what are the damages? Those are the 4 elements for your standard tort claim, right? With civil rights was there a right? Did the officer violate that right? As far as damages are concerned, is there a causation between the officer violating your right and the damages that you incurred? And finally, what damages are there? Isn't that fucking weird how it's the same fucking calculus? And then going into the settlement, like the settlement phase of everything is also the same. It's exactly the same. These are our damages. It's like it's exactly the same as a personal injury. It's exactly the same. Duty, breach of duty, causation, damages. Instead of duty, is there a right? Instead of breach of duty, is there a breach of the right? Like it's,
and it's just there's different things going on and stuff. Oh, family court. Okay, he's a family court attorney. Okay, like, but he tries to weigh in on subject matters that are far outside of his his ability to grasp. I'm not
far outside of my ability to grasp. What, like, find a specific thing. Like, you've accused me of saying that she got $15,000 and I can't prove she got $15,000. I didn't. I just said, I don't know. Maybe you have to win the bar fight to be promoted to best friend, or maybe you have to get into a bar fight with the current best friend. Like, whoever has the current champion is between the friends has the belt of best friend or something. But like, show me a specific error of law that I've made.
I'm saying he probably couldn't grasp this stuff, but it takes a long time, and he hasn't been doing this. Okay, he hasn't been doing this. It would take him a long time to catch up, folks. I'll tell you what. And he hasn't even begun to start. He hasn't even started to catch up yet. Look at him. He still is arguing. He's still arguing in support of frauditors. There is no argument. There's no argument.
Well, except that, like, frauditors get fucking settlements. Speaking of frauditors getting a settlement, didn't Turner get a settlement recently? Philip Turner. Let me see. Might recognize this Philip Turner. This is the Batosai. I have made a statement in the past, and I maintain that statement that Philip Turner does not understand the holding in Turner v. Driver. He doesn't, and that's fine. He doesn't have to. Sorry about that. But he did sue. And look at what we got here. The court has received a mediator's report indicating this matter was mediated, which resulted in a settlement. He got a fucking settlement. So there you go. And that was in September 22nd. So less than a month ago. Another frauditor win. Another fucking frauditor win. Where are we at? Here we go. 1983 case was created. A 1983 case was created out of tort law. Well, you could add tort claims to a 1983 lawsuit. Like if someone assaulted you under color of law, you could sue under 1983, that theory, and you could also sue under assault. Sorry, I'm gonna snort. Sexy, I know. One has to prove oneself. You aren't drunk enough to get it, okay? Mark got a settlement when he was on the other side too, for that matter. Yeah, I mean, like, so. Isn't Turner's channel named for the Adam West Batman dance? No, I think it's like what do they call those Japanese comics? Anime? I think Batosai is an anime. It is invisible penis season, right? Yeah, so there you go. All right, so yeah, I mean, settlements abound for frauditors, right? And if they're all manga, my bad, mea culpa. I don't know what the difference is, and I don't care. Don't tell me. Last time someone tried to send me down to some fucked up shit, and I saw it coming, you little fuckers. I saw it coming. I'm wise. I'm hip to your games, kids.
So whatever he's saying, it kind of just goes more to my point about the kind of lawyer that he is. And I wouldn't, yes, even murder. I mean, I forgot what the question was. I got distracted. Okay, fraud or troll.
So all lawyers are fucking powerful and amazing and awesome, except for Merv, who's a documented attorney. I'm the exception to the rule. That makes me exceptional.
Berquist, all right, for losing because she lost her case. and then voluntarily dismissed her appeal. The frog responded to further
involuntarily dismissed her appeal. Like, how do you get involuntarily dismissed her appeal? I don't see where you get involuntarily. Oh shit! I didn't do that. Voluntary dismissal. So it was not involuntarily dismissed. It was voluntary dismissal. And the case is dismissed to Federal Rule of Appellate Procedure 42B, mandate issued, no record to be returned, yada yada. So it was the order was on the agreed motion. So the motion was filed by Amanda, by Pink Camera Magic. She requested to dismiss it because of the settlement, which she found to be favorable. The court ordered on that motion, granting it, the case was dismissed. I guess I fucking didn't I? Josh calls it fist fighting his chat. Yeah, when he's drunk, or when he's not drunk. He wasn't drunk, but he was drinking. At least he didn't say hentai. Was that it? Was that the one? Was that the one? Don't look behind that curtain. Anime, animated, manga, pictures, hentai, naughty pictures, animation. Okay. Tentacle porn for everyone? Let's not. Let's not and say we did. Well, we know. Oh shit! You didn't hear any of that. Let me back up. All right. So back to this tab.
The frog responded to Frogger Troll, claiming that Frogger Troll didn't, quote, know that she actually won a settlement. She actually won a settlement in connection with this case, not attorney's fees or costs, litigation.
Yeah, she actually won the settlement, not attorney's fees or cost. It was each party was to bear their own costs. So she just won a check for $15,000 that she had to divide with her attorney.
Costs, but that she received a settlement amount in connection with this case. That, quote, her attorney thought she had a decent case, so they appealed to the Seventh Circuit, and she forced a settlement. She forced a settlement out of the defendants, and that
everything you said there, the attorney thought that she had a reasonable case. The attorney did not have to take this up on appeal. The attorney thought that this was a good enough case, number one, to take it on contingency, and number two, to take it all the way through appeal. That implies that he thought it was a good enough case. Like, you don't take, like, it's just so stupid.
She got money. She got money. She didn't lose.
She got money. She got a $15,000 check that she had to divide with her attorney. The city wrote the check to the attorney because the check goes into the attorney's trust, and then the attorney divides it out between himself and the plaintiff according to the terms of their agreement. The city doesn't know their agreement. The city isn't gonna divide the money up for him. One check goes to both of them. It goes into the attorney's trust account. Then when it clears, the attorney writes himself a check and he writes the client a check, and they both get paid and go their separate ways.
Well, she definitely lost, because whether you get money or not doesn't determine whether you win or lose. Case law.
If you sue for money and you get money, you won. Done. If you sue for money, my complaint for damages is for, let's say she said $50,000, right? 50. And let's say she only got 15. Did she win? Yes. How much did she win? $15,000. It's like if you place a bet, if you go to play lotto. If you go play lotto, and you buy that lottery ticket for the and the grand prize is like $64 million or whatever, and you win $20. People say, "Hey, did you win?" You'd be like, "Yeah, I won $20." well, they're, oh, you didn't win because you didn't win the entire thing. You're like, well, no, but I won $20. Like, she got money. They paid her. Like, that's a win. In personal injury, did you win your personal injury lawsuit? Well, yeah, they paid me $50,000. Well, did you sue them for $150,000? Yeah, but I still got 50. That's a win. Oh no, you didn't win because you didn't get 150. Well, that's fucking gay and wrong, right? Oh, good. 1A auditors should spend less time defending the right to film and annoy people in libraries, more time defending technical porn. No, that's gross. I mean, you do you, but ugh. Lawyers don't take chili cases because his lawsuits are not winnable. Yeah, exactly. Well, not only are his not winnable, but his are frivolous. Like an attorney could their license or could be in jeopardy. They could be subject to sanctions if they take his case because they're frivolous. So yeah, but they're also not winnable. Well, it seems that quite a few of us have been trying to find that last page on. Ouch. Hola. Fraudsters should spend more time auditing job applications. Well, I mean, that you are entitled to your opinion. That is your First Amendment right to express that opinion. Do you still have to pay taxes on money from a lawsuit? It depends. Personally, well, the attorney does. Fuck. That was fucking fun writing that check. My first big win. Jesus fucking Christ. Oh, it hurts. Tell you what, it fucking hurts writing. I can't tell you how much the check was that I wrote the federal government for, but it fucking hurt. It was not fun. So yes, the attorney does. Personal injury stuff, I don't believe is taxable because you're being made whole for losses. So there you go. I'm assuming a headphones guy isn't a lawyer. No, he is not. He is a felon who files pro se paperwork. I sure hope there are no kids here too. Oh Lord, here comes this weird interpretation of case law. He sees all the time that he made case law in the case that he lost. Oh yeah, I remember that. Achieving your stated goal is losing now, apparently. Yes, it is. Yeah. Don't display this yeah. Co-commander? I don't know what the fuck's going on. It's broken system blocking. Is there not? Is there not? Why do you always say stuff? Is there not? Ugh. Is there not a settlement that would have a stipulation of no admittance of guilt or wrongdoing? Generally speaking, all settlements. That's like every single settlement I've ever been in. Well, every single settlement for like monetary damages, like a family law settlement, whatever. But anyway, generally speaking, there is no. It's we're not admitting to anything. Blah blah blah. We're just paying you this money to go away. So it's almost a boilerplate term. So the IRS. Oh, it was more than a pound. It was more than a pound. It fucking hurt. I'm almost crying thinking about it right now. That was a fucking hard check to write, dude. The federal government sucks ass, and they're taking all of my fucking money. Not all of my. They're taking a lot of my fucking money and just shitting it away, and that really fucking irritates the living piss out of me. Oh, fucking hell. Well, I should monitor my language more closely. Can you file pro se on behalf of someone you have power of attorney for? No. Well, physically, can you? Possibly. Will a court accept it? Once they figure out that you're not an attorney, no, you can't represent someone. And Merv gets to pay the state of California. Oh yeah. That check was thankfully a lot smaller. But ouch, fucking hell, ouch. It's called go away money. Yeah, it's called go away money. Yeah, it is, but it's still a win because they're paying you to go away. Yeah. Let's get back to listening to the pro se experts out. Well, you guys, I'm trying to be interactive. You guys want me to be interactive, and then you don't. Assholes.
Court judicial orders and court orders adjudicating the case determine whether the case was won or lost, not whether anybody received any money.
The court orders adjudicating the case determining whether or not people won or lost. That's how you determine it, not by a settlement. Well, so the point of a settlement is to avoid having the case adjudicated. That's the point of a settlement agreement. It's to avoid that. But the way I normally tell my clients to approach a settlement is you're not going to get everything you want. That they're going to write you a check for less than you think your case is worth. But at the same time, they're going to write you a check for more than what they think you deserve. That's what a settlement is. Both sides win, both sides lose. The plaintiff is going to receive less than what the plaintiff believes the plaintiff was due, but more than what the defendant thought that it was worth, if that makes sense. So, but again, if your goal is to get money, that's certainly Radner's goal, Solomon Radner's, and that was apparently Amanda's goal because she asked for money on her complaint. That's why there was a monetary settlement value. If you ask for the money and they give you money, that's a fucking win.
Okay. So whether or not she received money, she definitely lost until the district court's ruling is overturned by a higher court, an appellate court. Then she lost, and she voluntarily dismissed her appeal before the appellate court ever.
She just went from she involuntarily dismissed her appeal to voluntary. Fucking Christ!
Is the issue? So she lost her case until there's a higher court.
So wait a minute. She lost her case because it was dismissed prior to the appeals court. So did the defendants also lose the case because the appeal was dismissed prior to being adjudicated? Or only the frauditors can lose. The city never loses. The city can write all the checks it wants. If they give the auditor $2 billion just to keep the case from going to trial. $2 billion. Well, then it never got adjudicated, right? Right? So the auditor lost. Even though the auditor gets $2 billion, the auditor would lose, according to this fucking logical genius spitting facts. Fucking retarded.
Order or opinion overturning the case, she lost.
Overturn. So Philip Turner went into Turner v. Driver. My understanding is he went into Turner v. Driver with the goal to make case law. He went in, he was paying his attorney an hourly rate. He was paying his attorney. The attorney wasn't pro bono, and the attorney wasn't on contingency. My understanding is that Turner was paying his attorney. He went in there to make case law. That was his goal. And he ended up getting case law made. And then he dropped, like, it got sent back down for, a lot of the case was dismissed due to qualified immunity, but it got sent back down on like one or two remaining issues. And he voluntarily dismissed the case without even receiving a settlement offer. Now, did Philip Turner lose that? Did he win it? Like, he achieved his goal, right? He got the case law. It is now the Fifth Circuit is clearly established in the Fifth Circuit your right to record police in public, subject to limited time, place, and manner restrictions, right? Did he win? Did he lose? I think he won because he achieved his goal. Amanda sues for money. She gets money. Does she get all the money she wants? Probably not. Did she get all the money did she get more money than the city thought she deserved? Probably. Did she win? She got what she wanted. She got money. I think that's a win. We're playing semantics though, so I don't even know why we'd bother.
When asked how the frog knew Berquist received the settlement, the frog claimed, quote, "Because I speak to people who know the auditor. I don't know if I heard it directly from Pink Camera Magic herself. Now he doesn't know who he heard it from. Or from Chi-Town Sue. And those folks are frauditors. Now I would trust that Chi-Town Sue would know the.
Well, I mean, I heard like it's not like when you've been in this community for long enough, if you're not only paying attention to the anti-auditor side will only tell you about the L's the frauditors get, right? They'll tell you about frauditor L's all day long. They'll tell you about all the cases that the frauditors lose. And the auditors will tell you about all the cases the auditors win. And if you're in this community long enough and you listen to both sides, you'll understand that there's a lot of fucking settlements out there. There are a lot of settlements out there. And, you know, for all you frauditor haters who are like, you frauditors are only in it to get settlements. You're settlement hunting. You're just trying to get a lawsuit so you can get a settlement. It is then, ergo, a fucking win when they get the settlement that they were seeking. Like you guys try to argue out of both sides of your mouth. You're only doing this for the money. Oh, but you got the money. Oh, but you still lost. But you're still in it for the money. And you got money, but you still lost. What the fuck? I look at settlements as a loss by the city because they just want the person to go away instead of showing the person is wrong and the lawsuit is trash. Well, no. I mean, they don't necessarily. I mean, there is a non-zero possibility that the city would have fucking lost on the appeal. Because I like Pink Camera Magic, but I calls him like I sees him, and that cop was on shaky footing. He might have still won on qualified immunity grounds. Great. But he was on really shaky fucking footing. So, I mean, the city's, they have attorneys and they're being advised by attorneys. The city is making a financial decision. They balance. Number one, we want to deter this kind of behavior. If we hand out big fat settlements, we're not going to deter it. If you ever sue a school district for an injury to a child, you're fucking going to court. You're fucking going to trial because they do not want to open that door to settlements, to easy money. If you want the money, you've got to fucking fight for it. You've got to prove it in court. There's no cheap settlements. And that's a deterrent for a lot of people because you got to pay experts. Medical experts are fucking expensive as shit. There's a huge burden, right? So, and a lot of hospitals, no settlements. We're going. It's arbitration, but arbitration is just as much work as a fucking trial. It just can theoretically get done a little bit faster, but it is still the whole fucking kit and caboodle, right? Rules of evidence, discovery, all that shit, right? I say all that shit right as if you guys know. But so the city has to balance like how easy are we going to make this, right? Because we don't want to just have people file lawsuits and attorneys know that they're just going to get paid out, right? So they have to balance that with the possibility that they win versus the possibility that they lose. And so they've got attorneys who are figuring out, okay, this is the odds of this is the odds of that. They've got bean counters going, okay, so this is like our break even. We win if we pay this much money, based on our odds of winning, odds of losing, and how much it's likely going to affect any future issues, right? So it's not just that they're saying you're wrong and the lawsuit is trash. I mean, if you're just wrong and the lawsuit is trash, they're going to win outright. They're going to win on a motion to dismiss. The appeal's going nowhere, and it's done. If it's really trash, like Chili shit is really trash. It's really trash, and it's not fucking going anywhere. It's really not going anywhere. Even if the 12B6 is only going to take care of like on the Las Vegas one. It's going to take care of all but one, and the one that remains my instinct is one will remain when this is all done. And the one cause of action that remains is going to go away on summary judgment. So that's my prediction, because it's trash. And so you're not going to have to spend for experts, for legal. He doesn't have any fucking injuries. They're not going to need a legal medical expert to come in and testify. That's a lot of money that they're not going to have to spend. So it's a little more complicated than that. But the city recognized liability. They recognized that they had a potential liability, and they got their bean counters out and they figured it out, and they did some math and they tried to lowball as much as they could. But there you go. Getting money is a win if that's what you're after. But if you're going to prove you're right, taking go away money instead appears like the money's more important than fighting your point. Right. But if you don't have, like, what about the people who can't afford to pay out of pocket for an attorney? Attorneys are expensive. I'm cheap as chips. I'm $2.95 an hour. And, if I spend 20 hours responding to discovery, that's a shit ton of money. That's a shit ton of money. I mean, into my pocket, great. Out of your pocket, bad, right? That's just discovery. And that might just be one round of discovery. So if you don't have that kind of money, what do? You sue for money. You get an attorney who's going to, and then hope you make case law along the way, right? This isn't a perfect world, and people have to make imperfect decisions. They have to make the best decision for them at the time they're making the decision. And sometimes that means they sue for money. When what they really want is just declaratory relief, but they'll ask for that too, and at least they'll be able to get some money out of it, and their attorney will get some money, and yada yada, and they'll get someone to represent them. I don't agree. They do a mathematical calculation. Law is not cut and dried. It's an argument. The court decides who's better. Sure. Didn't she, PCM, pop up in the Frogs chat shortly thereafter? Maybe. 100. I don't know what that means. There are degrees of success. If you win a case and can't collect, did you really win? Well, that's funny. So, like in a legal malpractice lawsuit, what you have to prove is that, but for the breach of duty by the attorney, number one, you would have done better, got a better judgment, a better outcome, and number two, that you would have been able to collect that better judgment or better outcome. You have to prove both of those, which makes it basically fucking impossible. I've done a couple legal malpractice lawsuits, and they are fucking next to impossible, which is why I don't have legal malpractice insurance, because the odds of, number one, me getting sued, and number two, successfully, are somewhere between the slim and none range. They will never tell you about the victories on the 1A side. Yes, they never will. They never will. They lie as much as the auditors, and you guys lie too. And, sometimes you're just wrong, but I think as Mark is mad that LIA received a settlement. Well, so LIA received a settlement. I'm assuming this is in the civil action that Mark filed his amicus brief in. Jesus Christ. And so despite Mark's best efforts to get his adversary a loss, he still got a settlement. Oh, I'll bet that fucking chaps his hide. But it chaps Mark's hide. Looks like YouTube is frying your intellect. Am I seeming slow? It might be just the coof. Most frauders, I love it when we start off with most. Okay. Most frauders don't go that far. They just harass people to get their mouth-breathing followers to pay them on PayPal, Venmo, Super Chats. That way, they say they'll sue, but don't. Well, how do you know? How do you know? I see a lot of fucking auditors filing a lot of fucking lawsuits. So, I mean, how do you know? What the fuck? I don't know what the fuck. You tell me what the fuck. Merb, looks like YouTube lately is frying your intellect. You're so animated lately. Well, I'm having fun. This is fun for me. I'm sorry. Mark, for sure, is butthurt about LAA and dislikes the hell out of Merb. But was he trying to get back at frauder trolls? Good gracious. Who knows? I don't know why. People always like to ask me, like, why? What motivates? And I don't know. Unless it's plain. Unless, like, they file a complaint that says my prayer to the court is that you give me money. Then it's really easy to determine their motivation. Beyond that, it's a little more difficult. Also, just want to say thank you for spending the time to educate us. Also, while being so entertaining and unmonetized for your charge, you're welcome. I consider this to be my pro bono work. The settlements tend to go to average people, not full-time YouTube frauders. The settlements tend to go to the people who file the lawsuits, the plaintiffs. And if the frauditors are filing lawsuits and the frauditors are getting the settlements, then my guess is it's going to the not the full time. Isn't LIA, Long Island Odds? Isn't he a full-time YouTube frauditor? Didn't he just get a settlement? The fuck is wrong with you, dude? Like, go smoke your copium in Mark Stout's stream, bro. Like, that's pure copium. Sometimes the auditors are wrong. And sometimes, even when they're wrong, they get a settlement. Sometimes the auditors are right. And even when they're right, they don't get a settlement. Sometimes. It's not perfect, dude. This isn't a fucking fairy tale. Oh, yeah. West Virginia's medical mal required expert witness testimony as a bar. Yeah. Well, technically, we don't have to have a expert testimony as a prerequisite to filing, but you have to have an expert testify that there was a breach in the standard of care, or else you're fucking going nowhere. And it's my firm practice. It's the one law firm that I work for that does medical mal. It's their practice. You come in, first thing we do is we get you to pay for an expert. You get an expert. If that expert reviews your file and says that you got a winning case, fine. We'll sign you up for the med mal. If the medical expert says then you can take the letter to the next guy, bro. Good luck, have fun. That makes sense. Thanks for the input on that. I'll keep that in mind going forward. You're welcome. The win of a settlement in this issue will soon become an issue of money to the government agency, which will create change just as a court ruling in favor of the auditor. I think you're overly optimistic there, Mob. Every time I have sued a government entity, like a school district or a city or a county, I have had to deal with an insurance person. I'm not saying that's always the case, but I'm saying that generally speaking, there's an insurance person involved. In my experience, my limited experience, only having practiced law for 5+ years as a first-year family law attorney, et cetera, et cetera, et cetera. So I don't think so. They understand that right or wrong, hell or high water, there's going to be X number of lawsuits. Like, you have no idea how many inmate lawsuits are filed every year. Tens of thousands, if not hundreds. I mean, fucking days of it. I talked to a guy who clerked for a federal court, and all he did all day long was review the informal paupers for prisoners complaints day after day. All he did. That was his job. There was some other stuff. There were some other clerks who got to do other things, but that was his fucking job. He'd read the fucking complaint and make a recommendation to the magistrate on like whether or not there was any. No, it was the judge. You make that recommendation to the district judge on whether or not there was any merit or any, and most of them get weeded out right there. Not like where there's clear where an inmate sues the the jailer for like a Sixth Amendment violation. You're like, how the fuck can a jailer violate your Sixth Amendment? And it's like that clear stuff. That's what he get to toss, or like say that this is clearly in violation. But if there's any way that they get at all even fix their complaint, then he'd have to make a recommendation, and a lot of them get through. But I mean, there's just so many. It's a huge flood. And if you thought that your extra drop in the bucket is going to make a difference, it's not. Like, there's a tidal wave of prisoner lawsuits. People like Mark Stout in prison preparing and filing lawsuits all day long. That's all they do. Prepare and file lawsuits all day long. And just fuck around with lawsuits all day long. They spend their time in the prison law library listening and talking to people like Mark Stout, thinking it's going to give them an edge up. Think, oh, I'm getting experience. Look at all these lawsuits I filed, until they turn into vexatious litigants, and they get an extra hurdle to jump over. So it's like, no, it won't. It won't. You think it will, but it won't. These are just soaked up by taxes. These are built in. There's one time. We sued a city and a developer. God, I forget. There's a Environmental Protection Act thing for California. California has it, where they have to go through a process and everything like that. And I had these clients. They weren't mine. I was an associate who was assigned the matter. And anyway, like, the client got 80 grand, right? They didn't get what they wanted. But 80 grand was like basically go away money, because like it turns out that the contractors and the developers, they're the ones who, like, the city was there, but the real parties in interest were the developers. And the amount of money that they had set aside for that lawsuit, the $80,000 was like a rounding error. It was a rounding error. It didn't. Like, they could have settled it for like 10 times that amount, and been like, "Hey, we got a fucking good deal." And cities, like, I mean, they got money baked in and insurance baked in. You're not going to do it that way. Okay. Will PCM settlement win deter the court personnel from acting in the same way towards auditors who record at the courthouse? Probably not. I seriously doubt that the defendants paid their own attorney's fees. Yeah, $2. Yeah, $2.95 an hour. Hell yeah, brother. I mean, I haven't done a study or anything on them, but I seriously doubt it. I seriously doubt it. Because like, on 1983 lawsuits, you got to remember, like, there's a lot of them filed. There's a lot of them that are filed that don't even make it to the point where they get a case number, just from prisoners. There's just so many. Well, I'd love to see your study on that. You're a psychic? Nice. It was an older case that settled, not sure which one, but not related to the more... Okay. Boo. I get what you're saying. Sometimes you have to wait if it's worth continuing to rack up additional fees, etc., versus settling and paying your attorney, walking away with a little something. Yeah, so I recently had a med mal. I was an associate on it. It wasn't my case directly. I wouldn't have taken it. In fact, I recommended it to the attorney who ended up taking it, and then he used me as the associate on it. Guy went in, was misdiagnosed as a hernia. It turns out it was a lymph node cancer. And anyway, long story short, good dude. I work with his daughter professionally, and great fucking case. And it's one of the rare times that that the hospital, they knew they were going to lose. I mean, this particular hospital never settles. Like, they go into it saying, we are not going to settle. This is going to go to arbitration. We're going to go all the way through arbitration. Just so you know, it's our policy. Despite that, they made this guy an offer. And, it was a good offer. except for the fact that he was going to die because he was misdiagnosed for the anyway. So the problem was to get the experts. It was going to run. We penciled out it was going to run like 45 grand, and like he needed 2 experts. He needed a family doctor expert because the guy who misdiagnosed him was a family doctor, and then he needed another expert, oncologist expert, to be able to say, like, if but for the misdiagnosis, the treatment would have been this. It would have been at this stage, blah blah blah. We would treat it, blah blah blah. It would have been yada yada. The guy's going to live, and so having to have 2 medical experts and looking forward to, you have to pay their expert to depose their experts. And so they'd have 2 experts. And so we'd have to pay their experts to depose their experts. They'd have to pay our experts to depose our experts, but we have to pay our experts to prep for the deposition. And then having them at trial and all the arbitration and the cost of all that, it was going to be like 45 grand. And he could do it. He couldn't come up with the money. And so he ended up having to take a settlement that was like chump change compared to what he could have won at the arbitration. And it's because he couldn't afford it. He just couldn't afford it. So I don't think so. I mean, I think it's great for your personal pocketbook if you could file a bunch of lawsuits and get a bunch of money. But I see so many shit lawsuits cluttering up like the system. I mean, look at all Chili's lawsuits cluttering up the system. Chili filing more lawsuits. What good would that do? Nothing. Nazed on the frauditor personality type. The frauders wouldn't shut up about him when they get. Well, they do. They do. Like that's literally the trap that that this fucking halfwit has tried to set, a Kafka trap for Pink Camera Magic. She can't talk about it. She won't talk about it because there is that non-disclosure agreement. And he's saying if you don't talk about it, it's automatically false. Like, that's dumb. Pink Camera Magic, a person that you would call a frauditor, is literally not talking about it. Like what kind of asshole are you? I guess it depends on the size of the organization. Yeah, I guess. And their funding, but usually they have it baked in. Like police departments have it baked in. Like look at like just going back to Chili's lawsuit, the LVMPD, once they determine that if the officer like should be covered by the city, then the city picks up the tab. Why does the city do that? The city doesn't have to. The city does it. It's built in. They have it baked into their budget, man. It doesn't hurt them. Pro boner. Don't want to be an amateur boner. Find a few good civil rights attorneys. Solomon Rodner's out there, and he will take your case on contingency if it's at all good. And if he doesn't take it, well, then you have a shit case. Even if he does take it, you might have a shit case. He might just think that he can settle it for you. And I've seen shit cases settle. I've seen literal shit cases settle. So, yeah. Like a trip and fall case that there's, by law, a de minimis crack in the sidewalk, which means that the landowner was not responsible for it. Still got a $40,000 settlement. 40 grand when they had no liability. Fucking crazy what happens sometimes. Oh, sure. Fire moth spelled backwards. I'm talking in a large municipality like mine where settlements can be in the millions when you have bad cops protected by unions. Good luck. You don't normally go to trial over $1 million. I'm just going to say that. Normally, like you go to trial over $1 million. You settle down in the maybe tens of thousands of dollars range. Over 100, you're probably going to trial. $1 million, you're going to trial. You're going to trial over $1 million. You're not settling for $1 million. LIA got the settlement in MD before he even filed anything. Stout's brief was in New York. Settlement before he filed anything? Nice. What municipality is yours, Laura? He's really flirting away. Obviously, I don't know, but from admittedly little, I've seen LIA for one has made hundreds of thousands from his channel, followers, merch. That settlement will get his car detailed. And give him cred, you know. and give him cred. And do you know how much the settlement was for? I mean, maybe you do, maybe you don't. I don't know. And how do you know how much he's made from his channel followers and merch? Have you seen his bank accounts? But those settlements are typically when someone is killed or severely injured, not the smaller stuff like auto. Yeah. Yeah. Oh, that sounds correct. Don't make me swat you again, BSBT. Even when someone's killed, unless there's like some like a racial component involved, even those you typically have to fight for. Unless there's a racial, unless people are threatening to burn down the city over it, usually you have to fight those two. Sounds correct. Don't make me swat you again. I mean, oops. I meant swat with the newspaper, not swat. Call the cops. Jesus. Broken sister, broken trusted Laura, flirting like mad. Prisoners got nothing better to do? No, neither do unemployed auditors, right? Alameda County just lost $10 in the case involving detention of a mom and 2 kids. No excessive force, even an arrest. Just a detention outside of Starbucks. Yeah. I mean, you got to prove damages. If you don't have any damages, you don't have any, you get $1. Here's your $1. Enjoy. 10 million? That would be interesting. That would be uncommon and interesting. Because I've had a couple unlawful excessive force or lack of probable cause arrests that I have been involved in, and yeah, they wouldn't have settled for millions, and it was more than just a detention on mine. So like, phew! I thought SWAT was coming for me. I feel sorry for the guy reviewing the inmate. Oh yeah, he is no longer doing that. He's now in private practice with a reasonable sized law firm. It wouldn't surprise me. I'm surprised nobody has spotted me yet. Well, I think Mark said he clerked at the law library. I don't even know how do you clerk at the law library. A law clerk is an attorney who does research for a judge. I don't know what clerk, like, he was a librarian. You're irrelevant. No one cares enough. I like turtles. Merb sues the municipality, gets a check, and pays taxes. Taxes go to pay the next settlement. It's a circle of life. It is. Yeah, it is. Yay. Oncologist experts probably aren't cheap. No, they're fucking not. A doctor left a roll of gauze in my knee. I contracted MRSA and almost lost my leg. No lawyer would touch my case. Every one of them hard passed it. Yeah. It's a lot. It's a lot. It's med mals are not easy cases. There's a lot involved there. And there's not a long statute of limitations. And yeah. And in California, you've got hard caps on a lot of shit. BSBT, why would someone do that? You only harm yourself with your misunderstanding of the law. We might learn something if you highlight a close case police interaction, MERB. We might learn something if you highlight a close case. I don't know what that means. The sixth sheep's sick. 3 fucking hours. This is like watching Welsh News Network. Jesus Christ. Well, you guys keep talking. Lauderdale versus Alameda. Ooh, Lauderdale versus Alameda. I'm going to guess that there is a racial component. Here we go. All 3 African American. She parked in a handicap space with a placard visible. They were on patrol for several minutes. After interplay, they determined it was a rental. They approached a vehicle. Another investigator in the morning. Oop. Oh, you can see this. Okay. Uh-huh. Uh-huh. Handcuff injuries. Okay. They search the purses. Nice. Nice. That's an illegal search right there. They search the trunk. Nice. Race discrimination. There you go. There you go. There you go. We figured it out. We figured it out. Your Lagerville versus it wasn't just for detention. You had more racisms in there. That's where you start getting the money. Everybody's so scared of racisms. So yeah. Law library and prison. Yes. Damn my fat fingers. Well, I found it. I found it. Laura's a big flirt for the record. No shit. I am a pretty princess. I am a pretty princess. Thank you. But it went all the way to trial, not settlement. Jury just went crazy with the award. Oh, so it wasn't a settlement. Jesus fucking Christ. Oh, you did say lost a case. Okay. Lost a case. Yeah. So I'm surprised that they didn't do a JNOV to try to reduce the award. I'm surprised. All right. I don't even know if I want to. Well, more than $5,000. That seems reasonable. For out of 15, they offered 700,000. They who offered $700,000? Your pronouns don't amuse me. I'm not amused. Who? Paul? Who offered $700,000? And who'd they offer it to? I'm competing with Josh. Oh, Josh has more viewers than I do. He's also more handsome than I am. And still nothing from Paul Berry. I wonder how many of my viewers are also in Josh's, and they're just bouncing back and forth. Like, so he sets an impossible task. I guess that's where I'll leave it there. He set an impossible task. She's stated she has a non-disclosure in not so many words. Well, not necessarily, but a lot of times. Yeah, I assume. Anyway, I'm gonna probably pop over there myself here in a second. But oh, you couldn't hear that. Jesus fucking Christ.
Who know, and there are lots of people who know there was a settlement end quote. The fraud for the claim, quote, I know what the final outcome of the case was, end quote, and quote, I think she got more than $5,000, end quote. Look, you don't even have to prove she got more than $5,000. Prove that she got any money, and that's it. And the discussion is over. I can see to your point.
So he sets an impossible task. The impossible task was to prove that she got any money. She's the only person who can prove that. She has a non-disclosure agreement. She can never do it, but you can infer. What are the facts? The facts are, number one, she agreed to the settlement amount. Number two, she was not under any duress to pay for it. The odds that they could have collected any attorney's fees are pretty slim. I don't think that was I am going to dismiss that as a factor. Solomon Radner is an experienced attorney with a long history of doing civil rights lawsuits. Jesus fucking Christ. Paul, if you were within arm's reach of me right now, I would slap you, not in the sexy fun way, but in the Josh after 6 beers kind of way. Because again, the lawyer, which lawyer, said they'd. Who's they? Who is they? What lawsuit are you talking about? Solomon Radner one more time. Solomon Radner one more time. Solomon Radner one more time. Yeah, I was too like you appeal $10 million. You fucking do. So Paul, where you're not getting it is I don't know what fucking case you're talking about, Paul. In what case was someone offered $700,000? Is this the LIA case? Is this the case that Jasper's talking about? What case are you fucking talking about? You have an adorable dog picture and with sad doggy eyes, but oof. All right. Well, I guess I'm not going to wait for Paul to pull his head out of his ass long enough to tell me what fucking case he's talking about. That'll be it for the night. Join me. Hold on a second. Let me pull up Stone Vet's stream, and we're going to share this copy, and we're going to paste this here. So if you haven't seen a Stone Vet stream, there is the link for his current live stream. Go over there and say hi. You might enjoy yourself. Thanks for watching. Have a great evening.